Just stated these facts. But you have stated these facts. Yes, file it. You have given an undertaking. See, you have a long
Item number 1, my lord, IFA for the petitioner. My lord, this is the matter, your lordship may recall, wherein the petitioner, my lord, challenged the, my lord, the continuation of a departmental proceeding vis-a-vis criminal case before the learned Central Administrative Tribunal. My lord, but the learned tribunal, my lord, subject to kindly, my lord, learned tribunal come to an abrupt holding that the charge memo was challenged by the petitioner. My lord, if your lordship takes the original application prayers, my lord, prayers makes it clear, my lord, that the petitioner challenged the continuance of both the proceedings.
Yes.
Now, my lord, if your lordship takes up the impugned order, my lord, which is assailed before your lordship, my lord, the tribunal's order dated, learned tribunal's order dated, my lord, 2nd of May 2024. Now, the very second page, running page 2nd of the learned tribunal's order, your lordship will find the prayers have been quoted at the top. When an order to issue thereby staying the interdepartmental proceedings so initiated against your applicant, wide memorandum number such and such dated such and such, till disposal of the criminal proceedings so initiated against your applicant, as the charges are same and identical in both the departmental proceeding as well as in the criminal proceeding. An order to issue directing the respondent authorities to reconsider the representation dated 7/9/2020 and 11/6/2021 made before them after giving an opportunity of hearing to the applicant herein, and to dispose of the same by passing a speaking and reasoned order within a stipulated period of time. Now, my lord, in these two applications, my lord, I have raised the point of, my lord, similarity in both the criminal case and in the departmental proceeding. My lord, this was the prayer before the learned tribunal. And my lord, if your lordship takes up, my lord, running page 4 of the learned tribunal's order, my lord, the second paragraph from the top, my lord, this is where the things got, I may say, my lord, went beyond what is there, or rather become murky. My lord, the learned counsel for the respondents, my lord, has got it, my lord.
Just a minute.
Running page 4, my lord, second paragraph, learned counsel for the respondents further submits that in the instant OA against the charge sheet is not maintainable as per section 19 of the Administrative Tribunals Act 1985, as it is not an order against which the applicant is aggrieved. The final order with regard to the misconduct of the applicant, if proved, will be passed by the disciplinary authority. Learned counsel submits that therefore this OA is a premature at this stage and hence not maintainable. My lord, thereafter the lordships have, my lord, the learned tribunal come to its finding, heard the learned counsel for both sides at length and perused the materials on record. During hearing on 9/7/2021, an ex parte order was passed by this tribunal directing the respondents to dispose the representation of the applicant dated 29/6/2021. In consequence thereto, the competent authority has disposed of the said representation by reason and speaking order dated 1/11/2021. Learned counsel for the respondent has also submitted that the Honorable Apex Court in the case of Secretary, Ministry of Defence Prabhas Chandra Midda reported in such and such has held that in the case of delinquent employee has any grievance in respect to the charge sheet, he must raise the issue of filing a representation. In accordance with those observations, representation of the applicant has been dealt with on merit regarding stay of the disciplinary proceeding pending criminal trial, so that no prejudice is caused to the applicant in disclosing his defense before conclusion of the criminal proceeding. And after discussing the entire fact, the respondents have passed the aforesaid speaking order, wherein the judgment of the Honorable Apex Court in case of Paul Anthony and Bharat Gold Mines Limited, such and such, is also relied upon. After perusal of entire record, the sole question needs to be adjudicated is that pending criminal trial, whether disciplinary proceeding can be stayed, and in consonance thereof, whether charge sheet can also be quashed by this tribunal. My lord, that was never agitated, my lord. Now, my lord, thereafter, their lordships, my lord, the learned tribunal, my lord, referred to judgments of my lord, Prabhas Chandra Midda, and my lord, the chairman LIC India Limited versus S. Misalamani. And my lord, your lordship, kindly take note, my lord. My lord, page 7. Excuse me. My lord, page 7 of the order, my lord, if your lordship takes up. Further, in R.P. Kapoor versus Union of India, reported in AIR 1964 SC 787, the question before the Constitution Bench of the Apex Court was that the petitioner therein has been suspended owing to a pendency of a criminal proceeding against him, which was challenged to unveil under Article 314 of the Constitution. Thus, this decision is of not much relevance for the resolution of the legal nodus before us. My lord, I don't know, my lord, who has cited this decision. Save for the observation, if the trial of the criminal charge results in conviction, disciplinary proceedings are bound to follow against the public servant so convicted. Even in the case of acquittal, proceeding may follow, where acquittal is other than honorable. However, on this aspect, we need not to go any further than the recent decision in Inspector General of Police versus A.S. Sumuthuram, reported in such and such. Since the contents and the comprehensive disclosure on all the prominent proceedings, the Honorable Apex Court has observed therein as under. The court has concluded, we are respectfully think correctly, that the acquittal of an employee by a criminal court would not automatically and conclusively impact the departmental proceeding. Firstly, this is because of the desperate disagree of proof in the two ways beyond reasonable doubt in criminal prosecution, contrasted with preponderance of proof in civil or departmental inquiries. Secondly, the criminal prosecution is not within the control of the department concerned, and the acquittal could be on the consequence of shady investigation or slovenly assimilation of evidences, or lackadaisical, if not conclusive conduct of the trial, etc. But now thereafter the lordship tribunal holds, considering the above preliminary objection with regard to non-admissibility of this OA under section 19 of the Administrative Tribunals Act, as the charge sheet is considered to be an order against which the applicant is aggrieved, and in the light of the aforementioned judicial pronouncement on the subject, we are of the opinion that this OA against the charge sheet is not maintainable. The present OA is therefore premature, and the same is accordingly dismissed. All pending MAs are also accordingly disposed of. Interim order granted, if any, stands discharged. The OA stands dismissed.
This has not been. What is the stage of the proceedings, right?
My lord, in terms of a lordship last order, my lord, I was called in to appear in the inquiry proceeding, my lord. In terms of a lordship last order dated 22nd of May, my lord, I was asked to appear on 2nd of June. Your lordship passed the order, I communicated, my lord, I was not called. My lord, this is the situation as of date, my lord.
So your WS you have filed, your written statement have you filed in the proceedings?
No, my lord. No, my lord, your lordship will find, my lord, I will be banking on judgment of Division Bench of the Delhi High Court, exactly on this very point, my lord, where the tribunal has proceeded in a matter which was not there before the tribunal. My lord, I may say exactly same, my lord.
What is not there before the tribunal? What is not there before the tribunal?
Before the tribunal, I have prayed for staying of the proceeding.
Yes.
But the tribunal came to a finding, I've charged I challenged the charge sheet. But I was never challenged the charge sheet,
That is the only ground for rejection.
But you find after dealing with this, ultimately in paragraph 9 of the learned tribunal's order, this is what is reflected.
And why an issue has been raised regarding non-admissibility of the OA under section 19?
According to the learned tribunal, the respondents have raised an issue. I do not know where during the hearing.
Why? What is their stand? We are not asking you whether it is correct. What have they said? What is the stand? Why they say it is not maintainable?
Your Lordship will find internal page 4. Second paragraph. This is the stand taken by the and has been reflected in the order. Learned counsel for the respondent further submits that the instant OA against the charge sheet is not maintainable, as per section 19 of the Administrative Tribunals Act, and it is not an order against which an applicant is aggrieved. The final order with regard to the misconduct of the applicant, if proved, will be passed by the disciplinary authority. Learned counsel submits that, therefore, this OA is premature at this stage and hence not maintainable.
Yes. And you filed the OA when?
I filed the application, in 2021. I'm just, let me check, the affidavit page. 5th of July 2021, as per the verification at page 48.
Where is your representation dated 7/9/2020?
Representation is at, my lord. Representation, my lord, your lordship takes up, my lord. Just a minute, my lord. Your lordship, my lord, 7/9/2020, page 181. 181, my lord. My lord, in the relevant part, my lord, if your lordship allows me to say, my lord, that starts from page 183, 182, last paragraph, 183, 184. কথা বলছেন।
Appears to be a detailed reply to the charges.
My lord, initially, my lord, when the charge was served, my lord, I made thereafter another representation was also filed. My lord, in that representation also, my lord, we have taken the plea, my lord. My lord, if I disclose my defense, my lord, that will prejudice my contention before the learned criminal court. And my lord, I will be nowhere. My lord, subject lordship kindly. My lord, this was the reason I approached the tribunal. My lord, tribunal came to abrupt finding.
Therefore, we are saying this is a detailed representation, 8 pages, everything that you could have said, you have said. What remains to be disclosed?
My lord, subject lordship kindly, my lord, I say, my lord, I have not spoken in clear terms. My lord, there are documents.
Just see.
My lord, there are, I understand, my lord, I say, my lord.
Every charge, everything that you have to say, you have said. And then you say, stay the proceeding.
My lord, the subject lordship kindly, my lord.
You say, I cannot disclose, and you have said everything that was to be said.
My lord, my lord, with
That
regard,
one line that is stayed because I cannot disclose my defense. You could have given a one-line representation that I am not going to respond to the charges. You stay the proceeding. You have said everything that could have been said.
my lord, there are many other things, my lord, subject
This is
lordship
as
kindly.
good as a WS. Everything. That's why we are going through it.
My lord, I have not filed any WS, my lord. Only a representation was filed before the authorities, my lord. My lord, your lordship will also take note, my lord, subject lordship kindly, my lord, and consideration. My lord, what I am banking on the very first stage, my lord, is this, my lord. The tribunal proceeded, my lord, wrongly. This is my sole contention. Now, my lord, what I'm also banking, my lord, if lordship allows me, that I'm just trying to show your lordship the division bench judgment of the Honorable Delhi High Court. My lord, on this, and then also tribunal was there.
Anyway, that is a different issue that the tribunal has not considered, that we are looking at.
My lord, but if your lordship takes up, my lord, my next representation at page 188.
See, what you have already given, it cannot be withdrawn.
No, my lord,
You may have given 10 representations after that. That representation, it is, you may, nomenclature representation does not make a much of a difference.
that's true, my lord.
It is 8 pages, every charge you have in detail, you have said what was the procedure, you are being made a scapegoat, everything, I have nothing to do. No
Okay.
forgery committed by me, no cheating committed by me. What remains to be said? You have laid your entire defense in that 8 page representation, WS, whatever you call it.
Yes, the subject lordship kindly, my lord. I understand what you're calling
disclosure.
from lordship, my lord, but subject lordship kindly, my lord. I may say there are other, my lord, critical
Therefore,
evidence.
what is the prejudice? That is the issue. Now, whether the tribunal has allowed or not allowed, what is the prejudice? What else remains to be said?
My lord, there are, my lord, subject lordship kindly, my lord, what I've been told by my client. Well, there are certain documents which are required to be placed, my lord, as the manuals, whatever it is there, which are required to be placed, my lord. If I take
All the manuals you have quoted,
my lord, I have to
come and see.
No, I understand. When your lordship has said this, my lord, I bow down to your lordship. I will never say anything, my lord, it's not there. Your lordship must have seen, my lord, and your lordship has said this word. No, my lord, what I'm beseeching is this, my lord, at this stage, my lord, as because, my lord, there are certain documents which I still hold on to my chest, my lord, which I can reveal, my lord, in the criminal trial. And, my lord, I hope, my lord, it's always, I can live against hope. That, my lord, if I produce those documents before the criminal court, my lord, I may get acquittal.
Recorded everything. Challenge.
Mm. It could be declared.
Your representation has been dismissed, rejected.
No, my lord. Initially, my lord, the tribunal directed the authorities to consider my representation. My lord, the authorities, my lord, after going through the cat's order, my lord, stayed that representation. My lord, further the tribunal directed me to give the judgments and make a detailed representation to the authorities, my lord, including all the judgments, which is more or less relevant at that point.
We ask you a query, why don't you give the response?
No, my lord, it's not been rejected.
Then what is the order passed on 1/11/2021?
Well, I'm just coming, my lord. The first order of the authorities, my lord.
Yes, 1/11/21. Show us.
Yes, my lord. My lord, if your lordship takes up, my lord, page 234. My lord, initially, my lord, by an order dated 22/9,
Again, we are asking you, where is the order of 1/11/21?
my lord, 234. It's my page, my
Page 34.
234, my lord. 234, my lord. 233 is the earlier order, my lord. 234 the latter order. 111 order.
You have not challenged this order.
My lord, your lordship, that order is in my favor. Your lordship kindly takes up the last paragraph, paragraph 7, at page 236. It says, keeping in view of the facts and circumstances of the case, various judgments pronounced by the Supreme Court and High Court, as well as the police investigation, the competent authority of the is of the considered
So
view.
if it is in your favor, then what remains?
No, my lord, at the tribunal, my lord, has dismissed the entire original application. My lord, this,
So what? If the authorities have already decided in your favor, then what remains? You should have withdrawn the OA.
my lord, in such being the situation, my lord, your lordship may remit the matter before the learned.
For what? If you say that the authorities have already decided in your favor, your OA has become infructuous. This matter becomes infructuous, then what remains?
But then, my lord, in such situation, the authority should not proceed it further, my lord.
We don't know. When it is already an order, you say it is in your favor, then what remains?
My lord, if your lordship takes up paragraph 7, last paragraph once, my lord.
You just said that it is in your favor, therefore you have not challenged.
Yes, my lord.
You were seeking a relief, for that you had made a representation.
Yes, my lord.
During pendency of the matter before the tribunal, the authority has decided the representation in your favor.
Yes, my lord.
Then why are you here? We'll just record that you withdraw the OA in view of the order passed by the authorities on such and such date.
My lord,
Nothing remains.
my lord, the learned tribunal, if lordship takes up, my lord, page 233 once, that is in my favor, 234 is in my favor. But my lord, the learned tribunal, while deciding the OA,
It is a very simple issue. There is no scope for so much of argument. The timeline is you seek a stay of proceedings during pendency of the criminal trial. You file a representation. No answer to the representation, you file an OA. During pendency of OA, that representation decided in your favor. Then what remains? For what you want to go back to the cat?
no, my lord, if your lordship passes such order, my lord, as because the order of the learned tribunal will be modified, my lord, as because the tribunal said dismiss.
What has to be modified? You withdraw the OA. If it is already decided by the authority, where is the question of any order being passed by any forum? What remains to be considered by the forum?
No, my lord, as present, my lord, as there is an order of dismissal, as the order dismissed is apparent, my lord, from the.
You withdraw it. We'll record that the OA is withdrawn in view of the order passed by the authorities on 1/11/21. Nothing remains. What remains? What is there to modify?
No, my lord, as because, my lord, I'm been even after, my lord, this order,
Hmm?
even after the 111 order, my lord, subject lordship kind consideration, I may be wholly wrong, my lord.
No. You have made that submission.
Yes, my lord.
We are not making any observation. You say already the decision on the representation is in your favor. What remains then? You withdraw the OA. We'll record that the OA stands withdrawn in view of the order passed on 1/11/21. Nothing has to be said at all. You are so satisfied with this order, then what remains?
No, my lord,
This is a subsequent development while the matter was pending before the CAT.
absolutely, my lord.
Therefore, it has become infructuous. We can record that. Get it over.
No, my lord, only thing, my lord, as because, my lord, now the authorities,
Huh?
my lord, even after having this order, which they have decided, I may say the authorities themselves have decided in my favor, and after the dismissal of the OA, the authority is taking stand and asking me to appear in the proceeding itself. Well, that shows their biasness. I must say, my subject lordship, kindly leave, my lord. If my lord, if I say, my lord, subject lordship, kindly don't take me amiss, my lord.
See, this representation, you say it has been disposed of in your favor. Read paragraph 7.
Yes, my lord. In view of the facts and circumstances of the case, various judgments, pronouncement of the Supreme Court and High Courts, as well as the status of police investigation, the competent authority is of the considered view that it will not be the interest of justice if the departmental proceeding is stayed until conclusion
So
of
this
civil
is a finding in your favor.
proceeding. Later on, my lord, however, in accordance,
However, what? The tribunal has kept it in abeyance.
yes, my lord.
So this is in your favor.
The last part may be in my favor. First part is not. Absolutely not, my lord.
Last part is in your favor.
My lord, it's kept.
Please read the last part.
Well, it says, my lord, however, in
Far-fetched
accordance with the
submission.
findings of the Honorable CAT, the departmental proceeding is no, my lord, I may say not exactly in my favor, my lord.
It is totally rejection of your representation.
Absolutely, my lord. I'm true, I'm extremely sorry, my lord. I bow down.
And you have not challenged this.
My lord, in supplementary, my lord.
Create a mess, then what can we do?
My lord, your lordship, my subject lordship, kindly, my lord, what I'm beseeching your lordship, my lord.
You see, under 21, your OA would have been admissible in spite of the objection because you had made a representation only. They made an objection under section 19, it is not admissible. But under 20, you had made a representation, therefore within 1.5 years, you could have filed that. You filed it within a year. During pendency, that representation is disposed of, rejected. Can any relief be granted to you without quashing that rejection order?
Lord, I understand what your lordship has said, my lord.
And if it is in your favor, as you say, then very good for you.
No, supplementary challenge করেছি কিনা আমরা এই অর্ডারটাকে চ্যালেঞ্জ তো কোথাও করা হয়নি চ্যালেঞ্জ করিনি ওটা বলছি অর্ডারটাকে তুমি it is order against you. You have not challenged. My lord, subject lordship, kindly, my lord, my understanding, my lord, I will be seeking. Lord, is this, my lord? What I following from lordship, my lord, I understand, my lord. Your lordship has said, my lord, that order is not in my favor. I ought to have challenged that order before the learned tribunal, my lord.
Or if it is in your favor, then nothing remains. There are only two ways out now.
My lord, only thing, my lord, what I'm beseeching at this stage is this, my lord, as because, my lord, the tribunal not went in this.
Forget about tribunal. Now there is a rejection order. Forget about tribunal's order. This was never challenged before the tribunal. What tribunal order can't be just for the asking. We will not issue a futile writ quashing an order for no purpose.
Should I come back, my lord? If your lordship grants me some 7 days time, my lord, should I come back if I get anything out of this, my lord?
You will not get anything out of it. You will have to challenge this order. Unless it is assailed, no relief can flow to you in any proceedings, whether it is the High Court or the tribunal. It had come into existence prior to disposal of your, much prior to disposal of your OA. In fact, soon after filing of the OA, within 3-4 months of the filing of the OA, you have chosen not to challenge it. Today you say it is in your favor. Very good. If you find that perception, then we can record it. If you don't find that perception, the only way out is to challenge it. There is no other way.
Understand, my lord. Your lordship kindly grants me 7 days time and let me come back.
No, what will you do in 7 days?
My lord,
This is a very settled issue. Any order which is against you has to be assailed. Without challenging the order, how a relief can flow to you? If it was a subsequent event, it was required to be assailed by way of IA, MA, whatever it is called there. We don't know.
understand, my lord. Just lordship grants me
You
7 days
say
time.
that the tribunal has only proceeded on the ground that charge sheet was under challenge.
No, that is the findings of the tribunal, my lord.
Now, even if we set it aside, it is of no avail.
My lord, if your lordship may set aside subject lordship kindly, my lord, if you set aside, the matter goes back to the tribunal. I have an authority, my lord. I may say, my lord, I can challenge that, my lord, filing a MA before the learned tribunal during pendency of the OA. Or else, my lord, a fresh litigation has to be brought into record, my lord. But that is what I'm saying, my lord. Lordship may remit back before the tribunal. I will file an OA challenging that order. I file a MA challenging that order.
OA, why will you file?
But if the my lord is remanded back to the learned tribunal,
Then why again OA you will file?
well, I will file an MA.
Oh,
I will
yes.
file an MA, my lord. That so, my lord, litigations after litigations may not be required, my lord, to just to settle this.
Yes, that will also avoid multiplicity of.
Absolutely, my lord. This is what I'm beseeching.
Yes, where is the finding on the issue considered by the tribunal? His submission has been recorded in paragraph 4. Come to paragraph 4, just above paragraph 4. Therefore, he is aggrieved on the ground that disciplinary proceedings should be stayed till disposal of the criminal proceeding.
Lordship,
Where is the finding on this?
Lordship's reading the representation.
No. Just the last sentence above para 4 of the impugned order. He is a specific submission that he wants stay of the proceedings till disposal of the criminal trial. Where is the finding of the tribunal on this issue? Please show us.
Therefore, he is aggrieved to the ground. Did the reply say
There is no finding, ma'am.
thereafter, Lordship, he is
The tribunal has thereafter gone on a tangent that whether criminal
criminal
proceedings.
proceeding because Lordship will kindly come to the what he has in the OA, Lordship. Lordship will see what this OA was for, Lordship.
His OA was for that only. We have seen it. That's why we are asking you. Come to page 46 of the brief. Relief at paragraph 8A.
Lordship, Lordship, the details of the application at page 38 says the instant application is directed against the arbitrary action of the concerned.
The relief that he is praying for is at paragraph 8A, page 46.
Yes, Lordship, that is the prayer.
That is the prayer.
Yes.
And that is recorded by the tribunal. It's not that it was not pressed by them. And then nothing has been. And the tribunal has proceeded as if they have challenged the charge sheet. They have not even prayed for challenging the charge sheet. So,
Saying the entire department.
Third Learned Council for the
Will that be remain? Your lordship's order would remain, my lord.
No, now there is, once we have disposed of the matter, where is the question? Can't do it.
Item number 2.
We can leave the petitioner would be at liberty to pray for interim orders.
I beg to appear on petition, my lord. My lord, on the last occasion, your lordship was directed to show the rule, my lord, the 75 rule, my lord. Hey, Bota, this is 65. Oh.
So both the wives are here.
Page 65, my lord. Rule 75, my lord, one.
There are two wives.
There is a two wives at the time of retirement, my lord. The ex-employee was given the declaration at page number 24, my lord. Regarding the family declaration, my lord, two wives and the three children. One children, first wife, and second children, one daughter and son in the second wife, my lord. Thereafter, my lord, page number 55. Page number 24, my declaration.
The two sons and daughter are out of. Are
daughters are married.
your son and daughter, or the son and daughter of the earlier wife?
First wife, my lord, son is there, one son. He has died, first wife died, and son is married, my lord. He is a major. And second wife is alive, my lord. He is the petitioner here, my lord. And the first wife.
We are asking you, there are two sons and one daughter.
Yes, my lord.
Who are they? They are son and daughter of the first wife.
No, only one son is first wife.
And what about the other two?
Second wife, one son and one daughter. Daughter is married and son is major, my lord.
So Namita and Chotan are your son and daughter.
Yes, yes, my lord.
And Jitu is son of the earlier wife.
Yes. At 55, my lord. Page number 55 is clear, my lord. 55.
Yes, same document we are looking at page 32. So Chotan and Namita are your children.
Yes.
And Jitu is a son of
First wife.
first wife.
Gulen.
Where is he?
He's married now major. He is married also and is major. He is not entitled to get the family pension.
Was any notice issued to him?
Yes, my lord. With the that is
in the tribunal?
No, that is not the there, my lord, available, my lord. It's a fact that he is a major. As per law, he is not entitled.
So whatever you say has to be accepted.
So that is the department, my lord, that should be.
Whatever the applicant and whatever petitioner says has to be accepted. That he is major, he is married, now he is not
That is
entitled.
not, my lord. That is not at the time of giving the.
If he is a legal heir of the first wife, can it proceed without his presence?
As per law, he is not entitled as because major. That is the money.
That's because you say so.
Above 25.
Above 20.
Above 25. He is above 25 years of age, and that's why.
That is your stand also.
Yes.
You have said so.
Pardon?
You have said so in the WS. In your reply, have you said that he is not entitled?
No, ma'am. In reply, we deny the second wife existence.
That is not the point. Whether she can get anything or not. If there is a first wife and there is a offspring from the first marriage, whether he has any claim or not, whether it is to be considered or without impleading him as party, we should proceed.
He had not been implemented in tribunal also.
That we have seen. That is why we are asking you. He says he is not entitled because you say so. Just because you say he is not entitled, therefore we should
Page
not.
number 55, my lord. in the terms of 75, they have stated here the status of the marriage of Srimati Gulen Rajbangshi was null and void as per the section 11 Hindu marriage, and hence no family pension was payable to her. And this way the question of hearing from the inquiry of CSWI, it is revealed that no other family member than the applicant is available on the date. As such, the question of sanctioning family pension is that has been concluded by the department. There is no other person.
That is what we are asking him.
Yes.
Yes, there is no other thing. So you are the only person now. There is nobody else.
No, there is no.
You said that your name has been included in the nomination. Where is that?
Yes, 21, page number 21, my 24 page number. The declaration is there, my annexure P2. Gulabi Raj.
He is in the railway service.
Yes, real, sir. He has retired on 2004 and died on 2009.
Is there any other nomination apart from this nomination?
My lord, this is the declaration by the applicant. And at the end, in this page 24, what my learned friend is writing, number 4 and number 5 paragraph clearly says that memorandum of advance sanctioning that goes to first wife in view of the above family pension of Gulabi Rajbangshi, second wife of late Biru Rajbangshi.
Oh, where is the declaration of 2004? Where is the where is the declaration of 2004?
24, page number 24, my lord.
Page number
24. Annexure P2.
That is declaration.
24.
That is the declaration. 2024 he has submitted, ex-employee. Disease employee has submitted, my lord.
And when did he retire?
Has returned 2004. Prior to the date of retirement, he has given the declaration, and which is also admitted by the railway authority in their reply also.
And what is the date of death of the first wife?
First time 2008, my lord. Page number, my lord.
2008.
Yes. 29/9/2008, page number 22, my lord. Annexure P3.
Annexure P6.
P3, page number 22. My lord, declaration next page, my lord. 21, 22. 22. 29/9/2008.
So after he retired,
Yes.
After
he
he
retired on 2009 on 2009, my lord. He has died 2009. First wife died 2008. Page 22 and 23.
and when was the second marriage solemnized?
Second marriage,
99.
19?
99.
99.
1999.
9.
From where we will get this fact? From where we will get this fact?
Yes.
Lord, it is in page number 77.
77.
77.
7.
Seven.
Paragraph 7.
Paragraph 7, yes. In our reply before the tribunal.
The disease stop weighed with Golapi Rajvanshi in the year 1919.
That during subsistence of first marriage, the second marriage is not recognized by your rules,
No.
and therefore there can be no payment to her.
No payment.
She is not a valid
That this is not a valid
marriage. Is not valid.
as per Marriage Act, as per contract rules, and 75 only will come
Rules of
when
ethics.
there are two wives. But we deny
And only and there can be two wives only if the second marriage is with permission of the employer.
permission.
On Monday we will pass the order.
As the declaration has been taken by the authority, Nachar, it is
But
presumed that the permission was taken also.
Heard the parties. This judgment is not, there is only one copy. और कॉपी करा के साथ एक इसमें रखना और एक साथ ये
My lord, in this respect, two judgment was given, my lord. If it is not available, my lord, this.
which one? Justice Chakrabarti
Cited two judgment earlier, it was given, my lord.
no,
But
there is
however-
one judgment of His Lordship Justice Chakrabarti.
Yes, yes, my lord.
That one you are giving.
Ah,
Yes, give it.
Yes.
ले लो सुप्रियो
আমাকে দিলেন কোথায়?
দিয়েছি
দিয়েছে?
Yeah. Get it.
Item number 3.
I beg to appear for the respondent.
service.
Yes.
What is TBOP stroke BCR?
Time bound.
Time bound.
One
One time
promotion,
time.
Time bound?
One promotion.
One promotion
One time.
The next grade upgradation up to
to remove stagnation.
16 years and after 26.
earlier, well, it was program, now it is. It was introduced that it will be after 16 years, TDOP.
So just to remove
time.
the stagnation.
Yes.
And what is BCR?
Biennial cadre review.
Career
After
revision.
26 years, further.
Internal page 6,
16 and 26 only.
Yes, please.
Or the,
When it was introduced, this TBOP,
yes.
you all of you 32 persons were working as?
As I am in India.
Huh?
I'm for the central government, man, Union of India. I'm appearing for.
Oh, the
But
tribunal has allowed the claim.
Yes.
So what is, why still
Yes.
they were working as UDCs?
They retired. They have all retired.
Now they've retired, they are
All-
working as postal assistants.
All retired.
Postal,
Postal assistants.
postal
And
assistant.
UDC were
All
merged and redesignated as postal assistants.
all were retired, Madam, sir. They claim benefit at least benefit extended to Arunesh Ghosh and other. Arun Chandra Ghosh. They wanted benefit as was granted to Arunesh Chandra Ghosh.
No, whether a Runesh has been granted or not is not relevant.
But they
If the
wanted
TBOP provides for granting it, it has to be granted. If it does not
I
provide,
see.
then it does not.
seniority. Madam, can you see the page 207 judgment of the Central Tribunal, which was filed, the application filed Arunesh Chandra Ghosh and Niranjan Bell. Well, can you go through the impugned order? Impugned order first.
Yes, nothing one thing, well, the case was that.
They were entitled on 16 and 26 years. They have been granted, but Arunesh has been granted from an earlier date.
And they were all juniors to the.
Correct. Huh? These persons.
respondents.
Yes.
They were granted on completion of 16 years, 26.
That is what we said.
We are not granted because we did not complete 16 years, 26 years. Now there is a decision by several benches.
You did not complete. What do you mean by that?
We juniors completed, but we did not complete 16 years and 26 years. Now our claim was that juniors have been given, senior we should be given. Now that was settled up to Supreme Court. Supreme Court. They have been granted benefits. Earlier, there was a decision that junior should be.
No, you are going on the law. We are first we are grappling with the facts.
Yes.
16 and 26 years you were entitled. You did not get. Why did you not get?
I did not complete.
So within 16 years you got a regular promotion.
No.
Then?
We were given nothing because we did not complete 16 and 26 years. Our juniors completed.
You did not complete means what? You had less than 16 years of service.
16 and 26 years. But our juniors were given.
If you had less than 16, then 26 question does not arise.
Yes, because our juniors were granted.
We are not asking about your juniors at the moment. We are asking about you.
My claim was that.
We are not asking what your claim was. We are asking about you.
Yes.
You came in service when?
We came in service
77.
later.
77, Madam.
We are seniors in the seniority.
We are not concerned with senior and junior right now. Please, how many years you put in service that we are trying to ascertain?
No, ultimately we come more than 30 years. But at the relevant point of time.
What is the relevant point of time? From which date you are calculating? When the TBOP came into existence? That is what we are trying to. 91. So it was to be given after the
83 and 91. This TBOP and VCR.
83 the TBOP came. And 91 came the BCR. And this was to be calculated 16 years from 83.
No, from the date of initial appointment. As LDC or UDC, because those chief cadres have been merged as PA.
Yes.
So our case was that we are denied because we did not complete 16 and 26 years. We are not fully completed. That service. That was initially challenged before other benches of the London Tribunal, which said that it should be given. Then I challenged.
If 83 scheme says.
No, that has been held to be otherwise constitutional. Due the rules of 309 by the Honorable Supreme Court in Nilama Jacob says. That's why the Supreme Court said that you give it to, because according to treatment rules, these higher grades are available on the basis of seniority.
Where is the TBOP?
If your TBOP scheme is, they have not. given. If your logic comes to one annexure, my lord, everything will clear.
Yes.
Page 19A, annexure
Page
19, page 55. This is the first case filed before the learned tribunal, Calcutta bench.
you were party to this.
No, I was
No, no,
I
we are
relied
not.
on it.
Just
Mhm. Yes.
what we are unable to understand is if it is from the date of initial appointment, how do you say you were not eligible? You
Because-
must have got it on completing 16 years.
No. We got it after 16 years. But we wanted that from the date our
Oh.
juniors got.
Just now you were saying we were never qualified, we didn't get it. When our juniors got it, then we asked for it.
No.
It was impossible.
I'm sorry.
It was impossible. We have been asking you twice, thrice.
I'm
You are
sorry, my lord,
repeatedly
I-
saying the same thing. Can't be. So you got it on the due date, but since your juniors got it
Earlier,
from an earlier date, you want a stepping up. That is your case.
from that date, yes. This decision was rendered by the learned tribunal relying upon a decision of the Honorable Supreme Court in the case of
Senior
Nilam
কোথায়?
Majid.
ওরা তো junior, আমার তো
Now,
উনিশ
this was
বছর
challenged
senior হচ্ছে।
ultimately before the Honorable Supreme Court. This was SLP was
টাকা ওটা দেখাও না ওই
now they have implemented this order.
Which order?
This order at page 55
55.
on the same issue. Initially, they used to grant it to the seniors also. From the date juniors are given. Subsequently, my lord, in the year 2000, my lord, they issued a circular setting, relying upon decision of the Honorable Supreme Court in case of art.
We are trying to go through the.
Yes.
Yes.
ইমের জুনিয়র কোথায়? দেখাতে বললে কালকে জাজমেন্টটা ইমের জুনিয়র ওই যে
And they are employees of postal department.
Yes.
উনিশ বছর ভ্যাকেন্সির কবে এসছে?
এটা
ভ্যাকেন্সির কবে জানো?
এইটা গ্রান্টেড ফিনান্সিয়াল অ্যাপ্লিকেশন এটা,
হুম।
ঠিক আছে। আর দিয়েছে 91
রুলের দোষ
অ্যাপ্লিকেন্ট
সিনিয়র কি হচ্ছে?
কিনে তো হচ্ছে না, সেটাই তো বলছি।
হয়েছে দেখতেছি তো, জয়েন করছে দেখতেছি এরা।
সিনিয়র আর সিনিয়র সিনিয়রিটি পাস সার্ভিসটা নেওয়া হচ্ছে, সেটা আমি প্র্যাকটিক্যাল এই 7-এর অর্ডার, ঠিক আছে। পেয়ারটা পেয়ার হয় maybe they have not completed the 76 him consequent stepping up pay applicant as per their partial job. It is clear.
But the tribunal has not decided anything. It has left it to them to consider
Yes.
and give whatever is due.
It was challenged from the Supreme Court. It was dismissed. Thereafter, they have been granted from the date juniors were granted.
But that's not under the order of the tribunal.
Lordship,
That is not a grant under the tribunal's order. Tribunal only said you consider it.
they consider and
They considered and gave. Therefore, it is not a question that this issue has been decided by the tribe. It has not been decided by the tribe.
now they decided earlier to extend the benefits to the seniors. It was withdrawn
Mhm.
to a clarification your lordship got in this order itself.
On 20th September 2000,
No,
it was withdrawn.
no, it was date was my lord. Most probably 2000, my lord.
We are saying 20th September 2000, sir.
2000.
20th September 2000, that is the date. They said now this seniority will not be a ground to give the grant from the earlier date.
Yes.
Now the tribunal says that you reconsider the issue in accordance with law.
Now-
That is all.
No, that is 17/5/2000. That is 17/5/2000. That's circular clarification. 17/5/2000. Lordship, page 57, lordship.
Page
57 of the paragraph 4. Paragraph 4. 75 to 1.
So 17.5 is the departmental order, but in this circle, the postal service have taken a decision on 29/2000.
No, but it is the directorate order.
Yes,
Directorate order. 17.5 2000.
yes.
Now, ultimately, my lord, there are other cases also in different different
So
benches.
therefore,
That these circular has been withdrawn.
that's not the point. You said that it has been granted by the tribunal, affirmed by the Supreme Court. So it is not granted.
Other cases.
It is not granted by the tribunal. That is the first thing. It is not granted by the tribunal.
Now, Lordship, kindly come.
What remains, it remains to be seen whether they are entitled or not entitled. It's not decided by the tribunal.
Now, Lordship, kindly come to page 64. Another decision.
How can you say that the tribunal has decided? You have read the order, still you are telling us.
Same benefit.
Sir,
Now,
this is,
what happened?
we are on you. Why should you make such a submission when there is no such direction in the tribunal? We have to read this 8-page order to find out
To be excused.
that, then we have to read these 9 pages to find out that what you are submitting is incorrect.
Now, ultimately, they were given. Now, my lord, ultimately, my lord, 75.
You made it so simple, tribunal granted, affirmed by Supreme Court, how it cannot be granted.
Now,
Before that, you said not granted, although you had been granted. So in one case, already twice you have made incorrect statement of fact.
now 17.5.
How should we proceed with the matter?
Now, that 17.
Every submission you make will have to be viewed with
Now, my lord, this 17.5.
uncertainty.
75 2000 has been withdrawn.
That's not the point.
Yes, because that is the only thing that they did not grant. Page 100, my lord. We have withdrawn that.
Which junior you are claiming stepping up with reference to which junior? Please give us the correct facts.
Yes. Arunesh Chandra Ghosh.
When did he get it?
Whether Urunesh Ghosh is junior to them or not.
Please, when did he get it?
What appointment?
What is this? Both of you will argue. Don't understand what you all do.
Initial appointment 64.
28 12 83.
Please verify.
Page 91 if you have to kindly comes.
Both.
28 12 83. This year 110 1991.
All these 32 applicants claimed with reference to Ernest Chandra Ghosh only.
Yes, it appears from the representation.
And where is the order of 27, 26, 7, 21?
Two zero three.
204.
4.
Yes, sir.
204.
Good, sir. Good. Very good, sir. Very good.
207.
Okay.
Yes.
Let me finally come to page 193.
Well, can you-
193. 2017, my lord, the Department of Post decided to extend it to all. And 100 some. Sorry.
Hmm.
This is March 2017.
No, this is no decision. This is a processing of.
So, yes,
My
thereafter, my lord,
my lord,
100.
kindly
100
come
is the
to page
100
207.
100 page.
207.
They withdrew that 75,000 they withdrew. Whereby it was denied. Earlier decisions were restored, whereby seniors were used to be granted.
And how do you say they are juniors to you?
That is an admitted question. That is not in dispute.
So from their reply that they admit.
Only kindly see the order
Yes, yes, yes.
on at page 207.
Let him show. He is saying it is admitted.
It's 207 Mali. Reply টা কোথায় আছে বলুন?
I have stated at page 94, my lord.
Hmm?
Page 94, I have stated my statement.
Oh, no, your statement does not make it admitted.
I am just referring to my statement.
You show us the admission. Show us the admission. You said it is an admitted position. So show us the admission that in the reply they have said that
Also, kindly come to page 215.
রিপ্লাইটা কোথায়? নিচে না?
One,
নিচে।
that they have not denied.
yes, this is specifically denied.
Here they have not denied.
No. They say so. That they had much more service than you.
No, passport service is another department.
Sir, there is no admission that they are juniors.
Also, kindly see.
In fact, they say that you cannot claim parity with them
Just
because they
again,
have rendered a much longer period of service than you,
No, that is admitted.
and there is no that
In the CRD list.
that is immaterial.
That is
There is no admission, as you said.
If say
They dispute this issue in so many words in their reply.
they did my lord.
You may read again. We have read it.
This,
Applicants got their regular promotion. Read second part of paragraph 6.
yes.
Yes.
Applicant got their regular promotion.
In due time.
Due time.
Yes.
The actually was granted promotion taking into account.
Past service.
Past
Yes.
service.
Where is the question of parity?
No, that is the.
You are saying admitted.
No, then my lord. Departmental rehabilitation, another department. Before joining Howrah division, again as per director's instruction, there is such and such. Account, RMS accounts will be considered for next higher scale of pay from the dates there immediately.
There is no such thing as admission. That was also an incorrect statement.
No, there is no denial of the fact.
Sir, admission has to be explicit. No, non-traverse means something else, and admission means something else. This much we know,
Don't traverse, my lord.
and you also know.
Don't traverse, my lord. They have not denied that fact.
There is no admission.
They have not denied that.
Third incorrect submission in this case.
They have not denied that. He was junior to us.
They have denied. They have denied in paragraph 6.
No, that is, Lordship, they were certain.
And that is why they are referring to Rule 38. Where is Rule 38? Show us Rule 38.
Name of discharge also, my lord.
Let us see. Where is Rule 38? order is number 13. Page number 13.
13.
Internal page 13. 2006, 206.
May I submit one thing, my lord? If you allow me?
Yes.
My lord, what happened? They are surplus employees.
Huh?
Surplus employees. The junior. Orunesh is our surplus employees. They came to postal department from another department. They were
By now we have seen that.
there. He has been placed below us.
You did not tell us so long. You were saying they were juniors. Now by now we have seen it. So now you need not. Now you need not say. You could have said that they have come from outside. They are in this department, but on the seniority list they are below us.
Yes.
You did not say. You say they are juniors. This is the admitted position. They are also saying that they are juniors. We don't know what to say to this.
In the state list, they are junior. Yes, yes.
Yes. So in what are you relying on? Rule 38. How does it help you? Show us.
Can you see the annexure 207? He is not junior today. He is senior most.
Page.
He is senior, much senior than those.
Page
Page 207 in judgment it has been recorded.
207.
My lord, can you see? 208. The applicant number 2 joined the said project.
Counting their service. the- the- 16 years and 26 years for them has been counted including service rendered in here they may have been junior. Service required was 16 years. They counted in service.
Yes, so they were granted taking into consideration their past service.
Yes, my lord.
Rendered in the Dandakaranya project, some project they were working.
That has to be considered. My lord.
Yes.
Past service has to be taken.
And
Senior-
when they came to the postal department, any seniority list has been published wherein both these persons are appearing.
No, my lord, but admittedly they are senior. They are senior to them.
What are we asking you?
Lord, sir.
Is there any seniority list? We
No.
are not asking you to give a judgment whether they are senior or junior. Whether there is a seniority list.
No, sir. No, sir.
No. Then from where you are saying that
Seniority list is there.
to us,
Then logically give me some, let them produce well, it is, seniority list is always there in the PA because
No, sir,
absolute
my lord.
promotions are made
Without any basis.
on the basis of that seniority list.
Everything is significant.
Next promotion,
so there is no seniority list also. If it would have been, it would have been considered by the tribe. So what is the reason given by the tribunal? Let us see.
now Lordship kindly come to another
Yes,
decision, my lord, page
The order
64.
has not been considered.
For what, sir?
By the Supreme Court.
64.
For what?
Just relying upon that,
Hmm.
another
But
decision was entered by
This
the
order has not been considered by the.
What relying upon what?
that to extend the benefits as has been extended to the applicants in that first way, that they have been granted benefits.
They may have. Whether you are entitled, that has to be seen.
Thing, we are on the same footing.
You claim to be on the same footing. So we have not been able to see yet that there is any seniority list where they have been placed before you, below you. There is nothing here. The tribunal, whether the tribunal has considered this thing or not.
I can produce the seniority.
Sorry, nothing which was not before the tribunal.
This order has not been considered by the tribunal.
Either it has been considered by the tribunal or the decision is unsustainable. It can't be. We are not here to substitute the tribunal. Just show us from the tribunal in which paragraph the tribunal has found that Arunesh Chandra was your junior. And what is the basis? Just show us the finding. That is all. There is nothing else.
No, I took the tribunal.
Lordship kindly come to page, internal page 10. Paragraph 6.1.
Yes.
It is not disputed that the applicants were senior to Arunesh Chandra.
You have not disputed. Yes, sir.
Yes, sir. It was disputed.
This is the finding. This is the tribunal's record.
In reply, we have stated.
This you are required to assail.
In reply, I have stated, my lord, in reply.
Sir, this is the find. The tribunal has recorded your admission.
No,
No dispute.
that is not proper. My lord. I disputed. In reply, it has been stated.
Where is that? Where is that?
So the reply, এখানে আছে দেখো। 2014, can you see? Page, rejoinder, 2014, 214. No paragraph.
Page 214. Then you are required to, if there is a error of record in the order, you will file a writ petition.
Can you see? I'm going to hear it wrongly, can you see?
Senior.
He is senior.
Order থেকে দেখা যাচ্ছে
Can you see?
junior to the appointment is 64.
Yes, Maharaj.
সেটা বলে
Okay. Yes. Good. Yes.
It comes to
wrong.
it comes to paragraph 12 of the at page 215.
এখানে
215, paragraph 12.
অর্ডারটা জানো এই যে এখানে দেখুন এটা wrongly hold করেছে
This tribunal held wrongly at para 6.2. The applicants who were admittedly senior to Karunesh Ghosh. He is not senior. Were granted financial appreciation. That is absolutely wrong, Maharaj.
Junior was
Applicants who were admittedly senior, not that much. Absolutely wrong. That is absolutely wrong.
it should say that
I have to.
specific denial.
In fact, this is a specific denial, but then it has been recorded.
Yes.
Your stand is a specific that in view of their being brought here under Rule 38, this junior senior will not be tenable.
Admittedly, Maharaj,
But the tribunal has recorded that it is not in dispute.
that is dispute. Tribunal wrongly.
If this is an error of record, then writ petition will not lie.
Admittedly, he is senior to them.
it is really surplus stuff are given bottom today.
See, he had much more service than these people. Much more service. They know it.
Wrongly
But when he came here, he was placed probably below them. So
But that
before the
was-
tribunal, you have taken a stand that they have come here under
That
Rule
was held
38.
wrongly by the tribunal, Maharaj.
Then this is the remedy. That's what we are asking you. If it is error of record, then this is the remedy.
So it was held wrongly, Maharaj.
got benefit of the
If this is the error of record, then you were
He
required
got
to
the TOP
go in review. You cannot come in a writ petition.
calculating past service, Maharaj.
Mr. Counsel, there is a record in the order that it is not disputed. According to you, that is error of record. Error of record will be raised in a writ petition or you have to go for review. What is the law? Tell us.
Then review could have been made.
Then why are you here? That is what we are asking you.
রিভিউ হয়েছিল রিভিউ হয়েছিল কিনা জিজ্ঞেস করছি So that was given, that order was given, that was not considered by tribunal.
What order was given?
The order, annexure কত? Page 93. Can you see page 93?
Page
93.
90?
Same order was annexed there. Page 93. Can you see?
What is this? Necessarily wasting the question. There is a according to you, this is an error of record. You
So
go
this
and
was
review.
annexed.
You go and review.
But I deny.
You will deny when they will go there. Not at this point.
This
You
was
will
annexed.
deny. You go for review. There is a question of, because here it is on the basis of a recording that there is no dispute.
That was not considered money. That was annexed to this.
So therefore, if it is an error of record, you have to go before the tribunal. File a review. The issue arising for consideration.
They may file application before the learned tribunal.
Yes.
If they are seeking a review, liberty for review, we will say liberty for something else.
You're not going to express any opinion on that.
No, we are saying seek liberty to file review. We are not saying file a review. We make it clear that we have not made any expression of opinion on the merits of the matter pending.
Item 4.
On the last occasion, his lordship has directed me, my lord, to file an affidavit, affidavit with regard to the stands of the state in this matter, my lord. আপনি কি in person করবেন?
হ্যাঁ।
আচ্ছা, এই কপিটা আমার কাছে এক্সট্রা কপি নেই। আমার কাছে কপি নেই, এখানে জেরক্স করে দিয়ে দেবো। আচ্ছা, ঠিক আছে।
I was also directed to bring certain documents on record. So I have brought it on record today. Along with that, I am also bringing an supplementary affidavit so that this court knows better in clarity.
We don't find anything like that in the order.
His lordship has only directed us, my lord.
No, sir, you said last time because I mentioned about the superintendent's letter and you categorically said that you please bring it on record. So that's why I brought it on record.
On the last day, you are Mr. Gupta.
Yes, Dr. Gupta.
Last day you had submitted that you are going to appoint a new council.
Yes, sir.
Yes.
But at that point, I am till now, I have not get a suitable person. So I am now decided. And moreover, last time the statement which they made, oral submission, that was misleading. So I can only contradict it because I know the facts of this case. Last time, sir, they said that the departmental proceeding is pending in 2014. I have filed an affidavit today. This document, where they say that this cancels the departmental proceeding 2011-14. So this is a contradictory statement they made on last day. And that is why there is an imperative need to file this affidavit.
Everything that they say in court, you will file a reply.
Sir,
Whatever oral submission are made, you will file an affidavit in response to that.
if they're making contradictory submissions, sir, I must let
Then the proceeding will never finish.
you say,
They may say anything in the court proceedings, whatever is in the record, that will be only considered.
categorically, this court categorically said that being that document pretendent Raghunath would said that there is no departmental proceedings on record. This court categorically said that please bring it on record. I have brought it on record.
Bring what on? We don't find anything from where you are
Only
saying.
last occasion, I remember, my lord, he has submitted that he do not have any counsel. That's what he said, my
Correct.
lord, he will engage. And accordingly, a advocate has been given his number to us so that I can serve him to this. But he told me that the client didn't contacted with him.
No,
So that's
I
what, my
sent
lord,
WhatsApp messages to him to send affidavit. I sent WhatsApp messages. I have on record that please I have not received the affidavit.
this is the problem, my lord, with regard to the when clients are appearing for the part. I have seen, my lord, in many matters. Now, my lord, his lordship on the last occasion has categorically told me with regard to the provisional pension. So, my lord, that provisional pension, my lord, 12 months provisional pension has already been issued, my lord. Lordship
There is,
will
what
find
is it? Just we don't remember. What is the fact? There is a proceeding against him.
Proceeding against him, my lord, there is a direction upon him, my lord, to furnish all the relevant documents. He has not filed all the documents. Subsequently, in terms of his lordship's intervention, all the documents has been handed over to the department. Accordingly, my lord, this report has been filed. It was told to us that vigilance is pending since 2014, and since his lordship desire was that he should have get the provisional pension. So accordingly, my lord, in page 12, lordship will find, my lord, it is a document of the superintendent of Raghunathpur. In terms of the finance department, so and so dated so and so is accorded towards provisional pension in respect of Dr. Anil Kumar Gupta, ex-MO Raghunathpur, so and so 12 months, 57,540 per month on the basis of the last drawn salary. And because of the, I had an instruction from the department, my lord, because of this pendency of this vigilance, my lord, the departmental, the principal auditor general does not, my lord, issue any provisional pension further unless and until that vigilance comes to an end or any findings has been come.
Not our prerogative. We cannot issue provisional pension to them, my lord. That is not our role, my lord. I am appearing for the principal accountant general, my lord. My submission is that, my lord, the case of the
No,
petitioner
no, just a minute. With his Which provision of DCRB is attracted, 14 or 10, which one in this case? Because you say there is a criminal proceeding pending. That criminal proceeding is in relation to his employment,
Employment.
not another criminal.
It's employment.
All right. What is your case? Tell us. What have you come to the tribunal for? What did you go to the tribunal
I
for?
went to the tribunal for release of my pension. And the tribunal on 31st January 2015, 25 gave directions that within 10 weeks, the provisional pension has to be sanctioned.
Where is that direction?
Yes, sir, this is in the writ petition.
Kindly comes to the impugned order, Millard, at the last page, Millard. Or Millard, page 2, Millard,
Yeah.
after hearing the
In my
submission
writ
and
petition,
considering the
in my writ petition, third page, sir, it is there that the order of the tribunal is there. Please read, I'm reading the order, last portion. The respondent number 2, the director of health service, shall initiate suitable action upon receipt of these statement from the superintendent for processing his vigilance clearance within 3 weeks from the date of submission by the superintendent. The respondent number 5, the superintendent of Nagpur, shall process his pension proposal once such vigilance clearance is recorded in favor of the applicant within 4 weeks from the day he received the vigilance clearance. While submitting such a proposal to the accountant general, he shall comply with all the 3 points raised by the principal accountant general at its memo dated 14th October 22. This has been complied by the superintendent's letter 7 June 22. Now, this order was given 10 weeks time, that is 70 days. That means up till 15th April, this should have been, pension should have been sanctioned. But still date, it is about 150 days. This provisional pension has not been sanctioned. I have not received any pension.
No, this direction is for pension, not provisional pension.
No. But that is why we have come here to, because how I'm going to survive, sir? At 3 years, I am without pension. 3 years.
Please, the direction is for pension. The direction of the tribunal is for pension.
Right, sir.
Any-
But that should have, there was a time like.
You have said you have not got it. You have said there is a time frame. You need not say the same thing 3 times. We have heard what you are saying. You are saying that there is a specific direction to get the vigilance clearance, sanction the pension within a time frame. It has not been done. Now, are you aware of any proceeding pending against you?
No,
Neither departmental nor criminal.
no, I've given it in an affidavit today.
Where is that? Let us see.
I'm giving it today.
There is no proceeding pending.
No pending proceeding.
And your instruction is that there is a proceeding pending. Let us see.
And I read para 3 of my affidavit.
You have been served with a copy of the report. You have given him a copy. Have you given him a copy of this report?
I have already just
Read the report, what they have said.
Their report.
Yes. Which proceeding is pending? Where is the detail?
in paragraph 14, Millard, it has been mentioned, Millard, it is stated that in addition to the above, the latest information as have been received from the Office of the Joint Secretary, Vigilance, Department of Health and Family Welfare, is that there is a departmental proceedings pending against the petitioner since 2014.
Why have you
Sir,
not given the detail?
I have attached the 2014 document in my affidavit saying that has been cancelled. So they are suppressing this fact.
Yes, where is that? Show us.
Yes, sir. Page probably 10 in my affidavit.
Page.
Page 11, sir. Last line, this cancels the department A dated 2011-14. And there is a page on page 10. I would like to read you what the Superintendent Raghunathpur has said. Can I read it for you?
I can see. I can see.
Last one. Okay.
Baba. Yeah. 2014, yeah, that order has been cancelled.
Yeah, that
No.
that was for departments. That no punishment has been given up till now. And this is the superintendent's letter. It says categorically, there is no record of it in the office of the superintendent.
And where is the letter of 2011-14?
2011-14, no, sir. I have 14-17-15 saying this cancel the departmental order dated 2011.
Now again you are repeating.
Yes, sir.
See, this is why when we have already shown it. Now when we ask you another question, you are repeating the same thing.
I don't have any letter after.
Then how do you know that that is the letter by which the proceeding was initiated and it has been cancelled?
Superintendent's letter here also. Then
Can you understand? Can you comprehend plain English? What is written there?
the superintendent's letter is thereafter no proceedings were taken, sir. That is why I have given an affidavit explaining the whole incident there. No, sir, because there is no proceeding. I have not faced any proceeding. Nobody called me after that. Yeah, no pending, sir. So that letter 14. They have not in exercise of the power of sub rule 10 of the hereby appoints Dr. Nirupam Misra, designated inquiry officer. Yes. The press in place of Dr. Tapos Nandi, West Bengal, to inquire into the charges framed against Dr. Anil Kumar Gupta under this. Right. Yes, sir. Thereafter. Okay, sir. Same charge memo, but I retired now without any proceedings. I retired without any proceedings. I retired without any proceedings. No, I have not received.
Yes, Lord. Only, Lord, it has been mentioned in this report, Lord, because so far the local authority is concerned, they are only, since the departmental proceedings is pending, Lord, that's what only they can give a sub for 12 months. Now, Lord, one thing, may I that is, Lord, I believe, Lord, it appears from the document, Lord, it is Rule 10, I believe. Lord, that has been mentioned. May I just, yes, my Lord.
No proceeding.
Page 11, my Lord, it has been mentioned in exercise of the power conferred sub rule 4 of Rule 10.
No such proceeding.
My Lord, page 11, Lord. Just now, Lord, you have seen that later. Yes, my Lord. 10, so and so. My Lord. My Lord. Whether at all anything issued, but only things that has been mentioned in paragraph 14 in my report, my Lord. Only thing it has been mentioned that is not written. My Lord, yes, my Lord.
So one more submission I want to make. My reinstatement in service was on the basis of the tribunal's direction. dated 24/7/2009. In that direction, I was exonerated from departmental proceedings. They had no authority to initiate any proceedings. And that is what I have mentioned in my supplementary affidavit I have filed today.
Tribunal with a particular case.
So
What-
my same case, sir. This is my
What did you go to the tribunal for?
restatement of my service.
In the present case?
No. When I was,
In the present case, you approached the tribunal for what?
I'm not, for this, I have gone for, to allow me the benefits of the order which were granted in 24/7/09, 21/6/2010, 19, 2019, and all these places to follow the orders of the previous direction. They have not followed it. They cannot take advantage of their own wrong.
Where is your OA? Show us the OA.
That way is not, my lord, annex it.
Where is your OA?
The order of the way should I take?
OA. We want to know what is the relief that you were praying before the tribunal. How can you seek such a direction that they should comply with all the earlier orders passed? If they have not complied, you are required to go for contempt.
I filed contempt proceeding, it is pending there.
Where is the OA, sir? Show us.
ট্রাইব্যুনালে ফাইল করেছেন সেই কাগজটা জজ লিখতে চাইছে
ওটা এখানে তো নেই।
সেটাই জজ লিখতে চাইছে।
That way is not here, sir.
We are only suggesting that you ask your lawyer to be here. You can appear, we are not stopping you. But you ask your lawyer to be here if you want the issue to be properly considered. You cannot raise issues which you have raised in the earlier OA. That proceeding is over. If they have not complied, the proper remedy is contempt. If your contempt is pending, whatever has to be done will be done there. Second OA cannot be done. If a second OA, they give the same order and they don't comply, then you will file a third OA. Please try to understand what we are saying. This is not the way, therefore we are asking you. And if in the third OA, same direction is passed, they don't comply, then you will file a fourth OA. That cannot be. Ultimately, the order has to be implemented through the process which is prescribed for implementation of the order.
This is for pension I am looking for, sir.
We don't know. Just now you said it is for compliance with earlier orders. Now you are saying for pension. What is the prayer? The OA is not before us.
I did not.
You can't say everything at the same time. Just now we asked you why. You said for implementation of earlier 3 orders. Now you are saying for pension, but we don't know.
I wanted to inform.
Where is the OA?
We are not about it today.
Then how do we know what you have filed the OA for? You are also not clear.
That the order of the OA, original order of the OA. I have filed in the WPST.
We are asking you what is the prayer in the OA. Where is? Show us. If it is for pension, then we will proceed further. If it is not, then what remains?
This is for pension only.
Show us the prayer, sir.
Yes, sir. In WPST, my prayer is there.
WPST just
Very difficult. You are going to.
যেটা আপনি ট্রাইব্যুনালে ফাইল করেছিলেন সেই পিটিশনটা জজ সাহেব চাইছেন।
আমি তো অনেক
One for
51 for pension we filed.
for pension. You have a copy. Can we see it?
I didn't bring it today, sir.
All right. It is for pension. Then you give the details. Why you are only giving provisional pension? Otherwise, if there is nothing pending,
Details of vigilance and everything.
Yes.
I'll produce everything.
in the meantime, they have sanctioned the provisional.
No, I have not received it.
Just now they have given you. What do you mean not received? Just now they have given you. Not received. Everything you have to respond by no. A report has been filed by the
Item 5. Five, 6,
2000 days means how many years? 6 years. Is he in practice? Respondent.
This is related to the tribunal respondent authority, the wife of a leave reserve voters who approach or the petitioner before the tribunal, wherein the respondent who approach for the pension benefit.
Pension.
Pension benefit. The person concerned will not the husband of the, this is the wife of the person concerned who was the leave reserve voter.
Leave reserve porter.
So that
Railways.
substitute.
Railways.
Railways. No, railways.
Section registration.
No.
So this leave reserve porter is
My lord, this writ petition is dismissed back in 2019. It's a restoration application which is lodged
Who?
against
That has been so. The restoration application I have to file.
2.5 years after this, my lord.
can 1.
Can one.
Where is the can?
Can one. Can one. On 29/3/2019,
Where is the question of condonation? Restoration of writ petition, where is the limitation? Limitation Act does not apply. There is no question of condonation. It was dismissed on 29/3/19.
My lord, now the respondent is 85 years of age, my lord.
Huh?
The respondent is now 85 years of age, my lord, and did not get the order, my lord, the pension yet.
So when did you learn about dismissal? What have you said? When you came to know about the dismissal?
Actually, the learned advocate for the petitioner who appeared for the applicant, he was not empaneled in the state government.
Was not empaneled.
He was not paneled. That's why Lord, he did not appear in the matter was taken up. Your Lordship, I have stated, Lord, the reason.
So you appointed a counsel who was not empaneled by the Union of Council.
Initially, your Lordship, page 3, your Lordship, page 3 of application for restoration. Initially, he was the empaneled, but subsequently change of panel.
So thereafter, he was at the time it was taken up, he was not empaneled. Earlier, he was empaneled.
And then when the matter was taken up, it revealed that no, it's not empaneled. That's why, Lord, it was unrepented. Late 19.
Where is the decision of Prabhavati Devi? Where is the decision of Prabhavati Devi's case, apex court?
But the Prabhavati Devi case is not applicable in this matter.
That's why we want to see. That is the only issue, whether it is to apply or not to apply.
That will I will submit.
Let us see.
Let us- as well.
So for 6 months, if they have worked as a, they have to be granted.
To the pension rules and the other laws, they substitute who was not regularists. He cannot claim for the pension benefit.
Is there any requirement in Rule 2318 that he has to be regularized?
Yes, I
It
am
is
yes.
So 2318. Rule 2318.
Rule 2381. 2381. Yes, I have got 2381 there.
Previously, Malad, this issue was Malad, taken up by this Honorable Court, this matter. Page number 4116.
There are two rules, 2311 and 2318, which say that
2318 and
substitute,
2311.
if he continues for 6 months, then he will be entitled to
As
the
per the
benefit.
judgment. Page number 41, my lord, sees once, because this matter was taken up by the Honorable Coordinating Bench of this Honorable Court. Successive times, my lord, impugned orders have been passed by saying the same thing, and successive times, my lord, the order have been set aside by the learned tribunal.
We are asking to show the rules so that once and for all, we
Yes,
can also see what is the rule. This is not the first and last case.
Rule 2318 and sub rule 2321. আছে এরকম কেন?
The tribunal has asked to follow the Prabhavati. See, there is whether he will get anything or not, it has to be considered in light of this decision.
But Milord, if the speaking order was the everything is the stated, Milord, why it is not applicable. The 2318, it is very much essential to produce, and the 23.
A speaking order was challenged before the tribunal.
Your logically, I'm placing the speaking order.
Where is it?
Yes. Speaking order, Milord, there are
Page.
There are three speaking order. I'm last speaking order I'm placing, which was considered by them. That is the 91 to 95. Decided on
91 to 95.
page
That is tribunal's order.
tribunal order. Then we have decided, then without your speaking order, that is the 75 to 76, your logically sees the speaking order. That is the date 28 January 2016, page 75 to 76. Operative portion will start from 76. P26.
Hmm. That rule is not there anywhere. It is not quoted.
Your logically see the meaning of substitute in terms of the Milord.
No, this your officer has reiterated the same order which was set aside by the tribunal. Tribunal said, don't rely on 1801. You look at Prabha Devi. Again, you have Prabhavati. Again, you have relied on 801. Same order has been passed. Be that as it may, where is 2318 and 2311? Just show us, please. Even in Prabhavati case, it has not been quoted.
Well, I was just trying to find out 2318. My lord, it shows something different in Indian Railway establishment, man. In the internet, in their official website, it says about, my lord, recognition of the association of the railway employees. I believe, my lord, subject to correction of my lord senior, my lord, it has been amended subsequently, perhaps. So that is why, my lord, the old 2318 is not available in the internet.
No, there is terms and conditions applicable to substitutes. That has been referred to by the apex court. The provision has not been quoted.
That has been reflected. Yes, that has been reflected.
2315, 2318 and 2311.
Yes. I'm young to relate.
So what this order is a mere reiteration. So this has been set aside by the tribunal.
Yes.
But what we are logically seeing is what is the meaning of substitute in terms of the pension rules. I am placing the what is
Pension rule is not required. You are required to consider as per Prabhavati Devi. The tribunal has said to consider as Prabhavati Devi. So therefore, if there is anything in 2318 and 2315 which will entitle you not to consider her as Prabhavati Devi, then only you can have any case. Otherwise, you can have no case. Show us the two rules. You are the railway. You should be having it. They may not have it. Where is it? Show us. Must be in some book. You can come with it tomorrow if you want.
or something. Because we have level based we have collected. I have noted, but I have not collected the.
The authority will give you the provision. It must be in some book.
This individual's entitlement, my lord, is noted in earlier judgment of this honorable court.
That
In
we have
this matter,
seen.
yes.
In all these cases, perhaps the brief in those cases would be having copy of the rule. After seeing the rule, the court has passed the order.
In this matter only.
No, in the other matters.
No, I'm talking about, my lord, in this matter itself, page number
Yes.
41.
Page
The ratio of the Prabhavati Devi is not applicable in this case. Milord, he was not a substitute.
Where have you said that?
Milord, that,
Where have you said that? Show us.
that Milord, you logically this. I have taken the point. You logically meaning of substitute. Milord,
You just now said he was not a substitute. What period he has worked?
yes, he has rendered the service. Only your logically says
He died on 8/10/65.
yes. 65. 1965, 1962 to October 1965. 3.5 years.
1962, which month?
April 1962
Yes.
to October 1965 as a LR porter. LR porter means leave reserve porter.
Again, we'll have to see the provision, then only it can be considered. Otherwise, it cannot be considered. This order of the tribunal is of 2018.
I must, my lord, bring to your lordship's notice that, my lord, after the dismissal of this, my lord, we take out an application, my lord, for implementation and contempt. My lord, in that matter, my lord, also the order is passed and it is also disposed of. So that order is also standing after the dismissal of this writ petition, which is not challenged also.
Already disposed of.
Disposed of that particular order of contempt. If I take your lordship, I do have the copy of this order. That would be, my lord, in 31st of March 2023.
Amen.
Give us copies of this order.
I'm sorry. Yes, my lord. I'll just give it.
Just come back. Can you produce the rule? We can consider it after recess, but we would like to see the rule.
2318 and 2311.
All these provisions, 2311, 15 and 18, three have been referred to.
Some time maybe accordance.
Otherwise, again, such order will be passed and the issue will remain open that whether he is covered by the rule or not. Let us see, and it will be.
But subject to correction of my lord, senior my lord, in the earlier round of litigation before this honorable court, it is already settled that it has to be covered by, it has to be guided by the Prabhavati's case.
In
This
his
was-
case,
In this case,
Not
this case,
where is
page
that?
number 41. In this case,
consider
itself.
the case of the person in the issue of the judgment, my lord, is not applicable. That high up.
That had been the case, then you would have filed a contempt.
But in this case, it is lordship.
If
But
there was a finding of the court that is covered by Prabhavati and they rejected, you would have filed a contempt. They must have been required to consider it in accordance.
in the light of Prabhavati.
So they are saying it is
Paragraph number 9, 10, 12, and 13, lordship says. Page 41 starts.
We have got below other judgment also where the blood is stated the substitute is not entitled because he has not.
no, no. The authority while deciding will not be observed, will not be guided by any observation.
Tribunal rejected in my case at that particular time.
Yes, therefore.
Against that, we came before.
Therefore, there is no finding.
But,
Let us see the rule, it will be
yes, yes.
finally concluded.
Item number 7.
For the respondent, my lord, applicant before the learned tribunal. No. Just to remind your lordship that there was a one page which was not readable. On that day, your lordship was pleased to call for the records. And that particular page is valid 280 of the writ petition. Your lordship may substitute that page. 208.
Yes. You are for the
Yes,
petitioner.
my lord. For the appellant department, my lord, my only grievances was that while the tribunal, my lord, we have referred, my lord, just to refresh your lordships, my lord, we have referred to one supplementary affidavit which has been affirmed on 6/9/2024, 6 September 2024, to bring on record the original order of the disciplinary authority by which the communication was made in favor of the inquiry officer. Now, this order or this communication or an order from the disciplinary authority was, though was not impugned in clear words by before the learned tribunal. Now, in effect of the order passed by the disciplinary authority, the inquiry officer directed that he will be calling for the cross-examination of the two witnesses. Now, in consequences thereof, my lord, the petitioner, the original applicant approached the learned tribunal. Now, challenging the notices, but the learned tribunal, instead of interfering with the original disciplinary order, only said that those letters issued by the inquiry officer is quashed. If your lordship will kindly see paragraph 11, internal page 8 of the tribunal's order. Now, my respectful submission before your lordship will be, when the order of the original disciplinary authority remains and the inquiry officer has acted in consonance with the orders of the disciplinary authority with regard to finding out the real reason for illegal gratification and other reasons. Therefore, my lord, we are
So
before
essentially his prayer B has been allowed. Please see what he has said in prayer B. He wants that the disciplinary authority should be directed to recall his order and communicate. So this is what the tribunal has done. It has given it back to the...
basically allowed prayer A.
No, it has remitted it to the disciplinary authority in terms of prayer B.
Lordship.
Directing the disciplinary authority to proceed in accordance with law.
Well, the disciplinary authority orders remains. Now, what in
So therefore, he can still consider.
therefore, these letters are in consequence of the order of the disciplinary authority. If the tree banyan
Not that
tree
he has
remains-
not raised an issue. He has raised an issue regarding the action of the disciplinary authority. For such a, if there was no averment, then it would have been a different thing.
Yes, Father.
Prayer B, he has said.
It be yes, Malad, subsequently, your lordship has noticed we were we were not considering the same. We were saying that it was not impugned, but subsequently, your lordship has said it that though the order was not directly impugned, but in effect, it has been impugned in prayer B of the original.
It is not impugned. He has said direction to be the disciplinary authority to recall his order.
Yes.
That is the prayer he has. So essentially, he has assailed the action of the disciplinary authority. And then it is up to the tribunal or court to mold the relief in whatever terms. It is not as if no relief has been prayed.
Now,
So
accordingly, if
why are you so aggrieved by this? When it is back in your hands, you proceed in accordance with law.
Malad, it is the same thing which I will have to do because this original order, I as an inquiry officer or the.
Where is this order of the disciplinary authority?
Malad, it has been in it is there in the supplementary affidavit, which we have.
The one which forms the basis of the
Yes,
two
ma'am.
communications.
Yes, that
In a
is-
supplementary.
Yes, ma'am. In the original writ petition, it was not correct. But subsequent to leave granted by your lordship, Malad,
Which page?
Malad, it is the first annexure, page 7. This is in reference, Malad. Your lordship has got the annexure. Malad, it is dated 11/08/2020.
So this is under Rule 15.
Yes, Rule 15. Malad, may I by laws leave to Malad, Mr. Bhattacharya is reading me in this matter. Mr. Bhattacharya is reading.
Yes, yes. Why not? Whoever. Rule 15.
Rule 15, my lord.
Action of me. Malad, may I, my lords, hand over the book.
এটা তো আমরা পাঠালাম স্টেটমেন্ট
Why the tribunal has interfered?
Tribunal as if, my lord, according to me, my lord, subject to correction, my lord, tribunal as if think, my lord, the inquiry officer is asking for, my lord, the inquiry officer is asking for that. That is not the fact. Fact is that disciplinary authority, my lord,
send it back to the inquiry authority for further examination of the two witnesses, though their name was not in the charge sheet, but their statement has been recorded. You will also find at page 82 and also page 78, my lord. '78, you will also find, my lord. Another disciplinary authority is well loath with the section rule 15 of the CCS rules, my lord, to remand the matter to the inquiry officer for further investigation, further examination of the witness.
Where is the charge memo?
Page 68, my lord, kindly see, my lord. Starts from page 67, my lord.
Where is the list of witnesses? List of witnesses and evidence.
82, my lord.
85. 85, your lordship.
Just one witness.
No, my lord, there's a no
But, my lord, the
witness.
statement, if your lordship takes up the annex 3, page 81, my lord, there your lordship find that starts from page 81 and relevant page is, my lord, 82. If your lordship kindly come to, my lord, serial number 25 onwards, my lord. 23 onwards, my lord, your lordship will find. And 24, Ranjan Joseph and Sri Malay Pal, these two persons, my lord, required to be examined. Their statement was relied upon in the, my lord, disciplinary authority.
Malay Paul and
Ranjan Joseph, 23 and 24, my lord.
Their goal is describing page 78. 78, 78 78.
My lord, regarding their venture in the proceedings, my lord, if your lordship can take up page 78. May I place it, my lord? Page 78, kindly seize, my lord. Investigation, as your lordship got it, my lord. Investigation had further revealed that Sri Maloypal, Inspector of Central Excise Anti-Evasion Unit, Kolkata, was attached to Sri M.S. Burman during the relevant period, and he was made the custodian of the file relating to Mr. Such and such. Inspector Maloypal.
what are you reading? What is this?
Well, this is the, my lord, imputation, my lord.
Huh?
This is the imputation, my lord. When
No, this page that you are reading, what is it? It is part of the charge memo.
yes, yes.
The charge memo, you may refer to 100 witnesses.
My lord.
If you give a list of witnesses and in that you don't mention anyone, then who is to be examined? Show the law. It's only issue of law.
Well, since
Person who has not been shown as a witness in the list of witnesses submitted, whether he can be examined or prosecuted. Let us see.
That is my case. Diplomas.
The format of charge memo is specified in the CCS.
Yes,
it requires it to be compartmentalized in so many forms. This is in furtherance of the principles of natural justice, so that the delinquent knows the charges what are the evidence, who are the witnesses, who are to be examined. Accordingly, he will prepare his defense and then the department will proceed. In your list of witnesses, you do not mention a single person, and then you say by after receiving the inquiry report that you examine these 3 persons. Whether it is permissible.
My lord, only I am, this is your lordship, my lord. If your lordship takes up the charge sheet, where the
Why?
imputation there was the statement of that. Those
So therefore, why not all the persons who are mentioned there? Why only these 2 persons? So that the desired objective, the desired result can come. That is not the law, sir. Fairness requires otherwise.
My lord, question is here, my lord.
It is open to you to proceed afresh. You may give a charge memo giving 10 list of witnesses, examine all of them, whatever you want. But this is show how it is permissible. It's just a matter of procedure. There is nothing, no fact.
My lord, yes. My lord, kindly, if your lordship kindly takes up, my lord, the rule 15, my lord.
Yes, 15(1).
15, my lord, rule 14, sub rule 15, my lord. If I place it, my lord, if it shall appear necessary before.
That is for the inquiry officer. That's not for the disciplinary authority.
My lord, what happened here, my lord?
14, 15.
Rule 14, my lord, sub rule 15.
This is for the inquiring officer. This is not the discretion of the disciplinary authority. He could have done it.
This letter, kindly see, now the letter has been sent by the, kindly see, that was, my lord, at page, my lord, 189. 189, kindly see, my lord. My lord, kindly see page 189, the letter given by the inquiry official, my lord.
There may be 200 letters.
No, it has been mentioned by the inquiry officer saying that these persons, the Maloipal and Ranjan Joseph, my lord, their name.
He could have called them under power of 14, 15. He could have done it. He has not done it. He is performing a quasi-judicial function. This law is well settled. For him, all these things are open to do. The disciplinary authority has framed the charge memo. So the report is submitted to him that, look, I have inquired, your charge is not sustainable or your charge is sustainable. Then it is his option to defer or refer back or to accept these 3 options. He cannot now at this stage introduce new witnesses and say that you examine them. Witnesses who were not named as witness in the charge memo.
Yes.
How can he do it? Where is that? Where is the enabling provision? It is only a question of law. There is nothing else to be seen.
The only thing, my lord, today, today we cannot satisfy lordship to this extent. But my lord, one thing, my lord, kindly, I think, my lord, it's a curable defect. I think, my lord, the simplicity of the names of the witnesses are not there, but their statement has specifically imputed in the charge sheet.
So therefore, we are saying you can. Who is stopping you? You are the employer. It is your prerogative. If there is a problem, you can rectify it. You can issue a fresh charge memo. You can name all the witnesses that you want. You still bring home the charge properly. But this way it cannot be done unless you show that there is some provision under which, because the entire purpose of CCA is to codify the principles of natural justice. There is nothing else.
And my prayer, my lord, before the tribunal,
Now, my lord, subject to lordship, my lord, correction, my lord, according to me, my lord, disciplinary authorities, my lord, as per the rule 15, my lord, can, my lord, ask the persons whose statement has been, my lord, relied upon in the imputation of the charge sheet, my lord. Irrespective of the name has not been mentioned in the charge sheet.
So show us law.
That is, my lord, that I relied upon. The rule 15 also says, my lord, it shall appear necessary before the close of the case on behalf of the disciplinary authority. The inquiry authority may, in its discretion, allow the presenting officer produce evidence not included in the list given to the government servant, or may itself.
Which rule you are reading?
Rule sub rule 15 of rule 14.
How can that discretion be exercised by disciplinary authority? What are you saying?
Well, that is, my lord. If you lord, the first line, if I read, my lord.
Yes. Read it slowly, don't read fast.
My lord, if it shall appear necessary before the close of the case on behalf of the disciplinary authority, then comma.
On behalf of, not by the disciplinary authority.
My lord, on behalf of disciplinary authority, the inquiry authority, my lord,
Correct. So he can do it. That we are saying he could have done it.
that is what
He is the only person who performs the adjudicatory function.
my lord,
For him, everything is open. Whatever he requires, whoever he wants, he can ask them to come examine, but that is also after a procedure. When he is called, he is given an opportunity. In this way, then tomorrow again a report will go, he will say, no, examine one other person. Still you are not holding him guilty. Can it be done? Cannot be done. We don't find
my lord, one thing your lordship will consider, my lord, the name of this person or the persons to whom, my lord, the inquiry officer, my lord, wants to examine, my lord, cross-examine. My lord, their names are already there in the charge sheet, though they are.
this is
in
the
hearing of
fifth time that you are making this submission.
all that because that is our
But
case.
that you have already said. That you have already said. Yes.
And my lord, later issued by the inquiry officer.
List of documents, elaborate. List of witnesses. See, there appears to be a defect in the charge memo. Annexure 3 is not followed up by a proper annexure 4. Annexure 3 was required to be followed up by a proper annexure 4 referring to all these persons whose statements are being relied upon. So this defect has occurred in the charge memo. Who is stopping you from referring? You can rectify it. What is the date of the charge memo?
2018, March 2018.
He is still in service.
Hello?
He is still in service.
Yes, is without. And Malik, I have voluntarily prayed before the tribunal, Malik, to direct upon the respondent number 3 to act on the basis of the concluded inquiry proceedings and its report handed over to the disciplinary authority by the inquiry officer. I have not created any impediment. Rather, I am saying that whatever the report has been submitted by the inquiry officer, you conclude your inquiry so that I can get my relief. So far, my MSCP is not getting, I'm not getting the promotions.
How any court can direct that they should proceed on the basis of inquiry report itself? He may decide to inquire afresh.
Oh, that
he can always do that.
No, it is by bona fide, Malik, that I'm not creating any impediment for them.
That is a different aspect, but that is not, that cannot be granted. The disciplinary authority has all three options. He can defer with the inquiry.
Yes.
Then, no, I will not accept this. Why should he be directed to act on it? At the same time, he can accept it.
Yes.
Third is that what he is purporting to do is the third option.
That is.
But for the third option, there appears to be no basis in the charge memo. Charge memo does not contain the list of.
There is no definite and the articles of
what the
charges
tribunal has done. Let us see what the tribunal.
The tribunal held the new evidence is uncalled for. New evidence.
New evidence. Then that is prima facie what we are also of the opinion.
We are saying well, this is not new evidence. Evidence already was there.
It is there. They are all mentioned. Yes.
We are repeating that it is not
in para 4 of the order impugned mallet, the learned tribunal has relied upon, and subsequently also at para.
CCS is nothing but procedure.
Yes.
So where a procedure is prescribed, then it can be done in that way or in it cannot be done. Has the tribunal given any liberty to proceed afresh?
No. In accordance with law. Liberty to the disciplinary authority to act in accordance with law.
then that leaves you all the liberty. You can do whatever you want. Have you relied on any decision or any judgment before the tribunal?
No, no, dispose of at the first instance without seeing the order of the disciplinary.
It has been, in fact, at the initial stage, it has been disposed of.
Initial stage.
If there was an opportunity candidly given to them to give their exception. Once they fail to file any exception, then the learned tribunal proceeded. On the last occasion, I have already submitted that particular daily order sheet by it. And they have also cited a judgment that is scripted in order on this particular part of the point. So it does not mean that they have denied the natural justice or they could not file their rebuttal.
Disciplinary authority was not considered by them.
But what we have now, my lord, argued before lordship, this issue in fact has not been dealt by the, my lord, tribunal, saying that no, since your witness name is not mentioned in the annexure 4 of the charge sheet,
The disciplinary order will not remain.
and my lord, the order of the disciplinary authority 11th August 2020, that was, though judgment may be, my lord, according to your lordship, the letter of my lord inquiry officer, that also, that letter has not been, my lord, touched by the tribunal.
Yes.
Where is the provision regarding the charge memo, issuance of charge memo?
Provision regarding the framing of the charge memo, that is 14(3), my lord. And the pro forma is also as page 241 of the CCS rules, my lord. 14(3)(b) would be important.
Fill up the lacuna.
You are relying on 1415.
Hello.
See the note below 1415. Which has not been produced originally. Evidence which has been produced originally. If there is lacuna in that, then it can.
That is there.
Only when there is an inherent lacuna or defect in the evidence which has been produced. Some judgment is required to be seen on this aspect.
But one thing, your lordship, my lord, this note, I think, my lord, if I, my lord, subject to correction, my lord, if I read, my lord.
Yes, you may read it in the other way. Therefore, we are saying.
My lord, this is, we are not trying to fill up the lacuna.
Oh, that you are trying to do. That is very clear. There is a lacuna in the original evidence because you have not supplied the list of witnesses. That is a glaring lacuna. It is writ large on the charge memo. With that you are trying to fill up. But then such evidence which may be called for only when there is an inherent lacuna or defect in the evidence which has been produced originally. So it can be read both ways.
The documents.
There is an inherent lacuna in production of the evidence originally, therefore they are doing it. But it is to be done by the inquiry officer, not by the disciplinary. And this, the very important thing is in the first line, before the close of the case. So therefore, there is no provision enabling you to do this. Yes. Anything else? We'll consider what you are saying. Anything?
Madam Eight. I am heard the wish.
I said you're out of station, sir. Lordship.
Reply has been filed.
My lord.
Reply. Have you filed the reply?
Yes, your lordship has seen yesterday.
This matter was taken up yesterday.
Yesterday it was taken up. Only one point was left. Lord, I have annexed your lordship's order. Your lordship's order has already been.
Oh yes, this is arising out of order passed in OA.
Wait.
Not contempt.
Only one point your lordship asked me.
Regarding matriculation.
Yes, Lord, yes. Lord, I have referring, Lord, the circular. I have annexed it. Page 7 in my exception. Your lordship will find that circular.
Exception.
It is specifically mentioned here that only read and write. Educational qualification is only.
Lordship, I said out of stations.
Huh?
Out of station. My senior.
He has said his senior is out of station.
Every day.
Every day.
I don't.
Everybody is in station now. Nobody is out of station.
Once to adjourn on this Tuesday.
Nowadays, everybody is in station. Nobody is out station.
Yesterday he was appearing.
Online.
Everybody can appear through this.
Yes.
What are you showing? You said that you are going to show some judgment.
That is your lordship. They have taken time from your lordships.
Yesterday you said that in some case we have directed to verify the matriculation certificate.
Yeah.
Today you are saying matriculation is not required. What is your stand?
It is that.
What is your stand?
It is that your lordship's order I have annexed.
You also served me, no, sir?
Your lordship has given time 1 month. They have prayed for 1 month time for verification of the certificate.
We don't know this one paragraph order. We don't know by
Yes.
which this.
For that reason, my lord, I have said your lordship has given time 1 month time for verification. If that be so, my lord, they have said that they will. If it is correct, then they will give appointment.
No, but we don't know it is a one paragraph order. From this we cannot make out what verification of testimonials.
It is their contention, my lord. They want to verify that certificate.
Give her a copy of this.
They want to verify it. And another I have shown that the circular, which they have given appointment.
Give a copy.
Yes.
Give her a copy of both. Then we
Yes.
can consider. Copy.
That is affidavit.
No, that you are handing over just copy, or it is also by way of an affidavit?
By way of affidavit.
Then give. So you are filing 2 affidavits today.
2 affidavits. This affidavit has already been given in March.
Then why are you giving us so late?
But it was not taken up, so that it is not taken up. It is the
2 supplementary affidavits. 2 supplementary affidavits are being filed.
Right?
19 June. Yes.
আমার নামই আছে দিয়ে দিচ্ছেন
Item 9, my lord, I appear for the petitioner, my lord. Yesterday,
Yes.
I appear for the petitioner, my lord. Yesterday, I could not appear, my lord. Your lordship accommodated.
In item number 9, my lord, Mr. Ujjwal Rai is appearing on behalf of the respondent, my lord. He's on leg at code number 11, my lord. Seeking a my lord, 1 day accommodation, my lord.
Why, sir?
Being led by Mr. Ujjwal Rai, my lord. He's on leg at code number 11, my lord. Kindly accommodate this for the day, my lord.
What point is involved, my lord? A person was.
So now the issue of review is not there anymore. That is already decided now.
Seeking only 1 day's accommodation.
This is the only case, or there is another case? One case.
Yes, sir.
He is a private respondent in his absence, if you know.
I'm grateful.
My lord, I accommodated yesterday me, my lord. I cannot.
I'm grateful.
Grateful to your lord.
I'm grateful, my lord.
Not today. As prayed by learned counsel for the respondent. Give your appearance.
My lord, I'm appearing for the petitioner.
I appear for the respondent in this matter, my lord. Copy there, my lord.
Bangalore. Perhaps.
And losers case, my lord.
What is the issue? PET?
PET, my lord.
And losers case, my lord. These are Southeastern Railway, my lord.
PET, then where is the order? WPST, is it WPCT 88 order?
My lord, the order starts at page 279 and the relevant portion is at 284.
How many petitioners?
One petitioner only.
279.
Page 2.
284.
282.
My lord, it starts at page 279 and the relevant paragraph is at page 284. Wait. Sorry. 259. Sorry, your lordship, it's 259. Apology, your lordships.
Page
259.
259. 259.
Second paragraph and the second last paragraph.
Yes, my lord.
Second paragraph and second last paragraph. What has the tribunal done? Decide the pending representation.
that is pending.
My lord, there was two ways.
Just wait. If it is pending, you decide. We are not on that. But we will hold that this PET cannot be insisted. Everything else you consider.
That also in the light of the Supreme Court judgment, if there be that your lordship keep open, we will decide.
My lord, actually the judgment they are relying upon has already been rejected by the.
We are not going to go into anything. Your apprehension is regarding PET.
PET, my lord, the candidate has been disqualified in physical efficiency test.
How are you saying it is yet to be considered?
No, my lord. My lord, kindly come to the results. I'm telling your lordships.
No, just a minute, sir. The tribunal says to consider the pending representation.
Before that, my lord,
So where is the decision that based on PET you have been disqualified?
my lord, before this consideration order, there is a result. And in that result, the candidature of the petitioner has been rejected.
Then why, how it is saying that
My
it is
lord,
pending?
actually, there is two sets of OAs against physical efficiency test.
Yes.
My lord, the first order starts at page number 192. The petition is not annexed here, my lord. I can show your lordships. I can present the petition. My lord, this first OA was filed against physical efficiency test, and then her candidature was rejected. Then the second OA was also done on the same issue. But the tribunal, instead of entering on the merit of the matter, they have simply directed that they trust the authorities will consider the candidature of the petitioner in accordance with the law.
No,
but
no.
they have not considered. Yes,
you have represented.
No, my lord. I have prayed for an order on merit. My lord, I can differentiate the two judgments.
When it was rejected by the authorities.
Kindly peruse page 6.
Just a minute. On what day it was rejected by the authorities?
My lord, at page 3 to
give us the date, sir. Why do you want
7/11/2023?
7/11.
7/11.
And on 2011 you have filed a representation.
2011.
Then
my lord, the order, my lord, there was a prayer to consider to pass the order on merit.
And you are saying the tribunal has on its own said that you consider. Please don't make such submission.
My lord, the
Please
representation
give
is certainly
correct
pending.
facts. Don't give incorrect facts.
No, my
It
lord,
is
I'm not
very-
giving incorrect facts. Matter is, it is fact that, my lord, the representation was pending.
Yes.
But
Now you are saying, till now you were saying no representation.
No, no, representation was pending.
No, no, what? You just said the tribunal on its
No.
own has said.
My lord, previously also there was a direction.
So you
in the-
filed a representation, that representation was not being decided, then you approach the tribunal.
Yes, my lord.
Now, what was the relief that you claimed before the tribunal?
My lord, may I give the OA? May I show your lordships? Because the prayer
If
was.
the prayer is recorded in the order, come to the order.
My lord, kindly comes to page 360.
ট্রাইব্যুনালের অর্ডারটা যশোর
ট্রাইব্যুনাল অর্ডারটা যাইছে কোনটা যাইবে?
$363.
My lord, 363. The order. My lord, but the prayer was to pass an order considering the merit of the claim of the petitioner. But the tribunal has left the matter with the expectation that the respondent, while the respondent has already rejected my candidature. And lots of a series of judgments are there, my lord, in this regard, where it has been told that the candidature of the petitioner cannot be rejected. And my lord, I can show few other similarly circumstanced candidates who have failed disqualified in PET, but they have been offered candidate appointment.
In case it was required to adjudicate. Send him back another 6 months. Cite it. The tribunal has not considered your prayer. Your prayer B is for setting aside the.
Yes, my lord.
We have seen that.
And my lord,
This is
WPC.
application of duty by the authority, by the tribunal. It was required to decide the issue. It has not decided.
My lord, previously another OA was filed on the same cause of action, and that was also disposed of by the tribunal by passing a consideration order upon the respondents on the same cause of action. On neither occasions, the tribunal has either decided to enter with the merit.
Yes, very well. So where is this rejection of 7/11/23?
My lord, at page 321. Serial number 16. Shongita Mukherjee, not qualified. NQ.
Serial 16.
Serial 16.
Not qualified. Not qualified in what?
Not qualified in physical efficiency test. My lord, the first page of the result is at page 316. It contains a list of candidates who have been disqualified in physical efficiency test.
Oh, this is a list only for PET.
Ineligible candidates.
On 15/10/23. And all these persons who have been disqualified, none of them have been granted any appointment.
No, my lord. My lord, may I hand over one document for your lordship's kind consideration?
What is it?
My lord, there was a candidate. Her name was Nivedita De something. So she has also filed a writ petition. She has also been disqualified in physical efficiency test, but she has been appointed, given appointment, and your lordship has disposed of the writ petition.
That is why we asked you. None of them have been given. You said no.
No, in that result, none of them have been considered, except a few.
And what come to page 317?
317. Yes, sir, lordship. Joydev Kajli is considered, despite being not qualified in physical efficiency test.
Unless, unfortunately, you don't go through the brief. That is the problem. It is Joydev.
I've marked it actually, but I forgot. Sorry.
So he has already been appointed.
Yes, sir. Yes, sir, lordships. I marked it in my brief also, but I forgot.
WPCT 176 of 23.
23.
Where is that order? You have mentioned, therefore we remember.
Which order, lordship?
WPCT 176 of 23. That must be the writ petition of Joydev Kajli. He has already been appointed from this very list, though he was not qualified in PET.
Has presented this order, but my lord didn't consider it because it was an interim order. It was not a final order. Yes. It was an interim observation, and based on that observation, the respondents have given them appointment.
But he has been given.
He has been given appointment.
So how do we know that he has been given?
And this judgment actually, my lord, on the very first day I've submitted.
How do we know that after this interim order, he has been given the appointment?
My lord, he has been given appointment on that day. I've submitted the appointment letter of that person also, Joydeep Kajli.
But we have forgotten, sorry. What do you mean on that day you have given? Where is the order? Show us.
My lord, can I show for a different candidate?
From this list, any candidate you show. We are not interested in any one particular candidate.
No, the appointment letter is, I don't have the appointment
In
letter.
this,
It was noted in the judgment that the person has been given appointment.
give it. Where is WPCT 88 as paid 256? Yes, what is this on pick and choose basis you are doing? Somebody from the list you are appointing, somebody from the list you are not appointing. You are resisting in court. A very unique pattern of litigation is emerging from your organization.
You are coming before the court and getting a specific order. That we are not in those judgment are of judgment in personam. This is not judgment in name. But we have
The fact that PET cannot be made a bar is a judgment in personam.
That judgment was only applicable to those persons who come before your lordship.
The undertaking of the railway authority that based on PET nobody that is in personam.
Your lordship kindly finish this supplement the affidavit, short affidavit on.
No affidavit. Come to the judgment where you have said that PET cannot be made the basis. What judgment? What affidavit?
That is the judgment that is binding in respect of those.
We don't know. This is your undertaking. How are you doing it on a pick and choose? Who is this?
We are not PK.
Whoever he wants, he will say not required, and whoever he doesn't want, he will say it is required.
We are now we are guided by the joint procedure. To that one, I have filed a short affidavit.
No affidavit.
Short affidavit.
From this list, you have given appointment. What do you mean short affidavit and long affidavit? From this list, you have given an appointment. Although disqualified in PET, what is the basis?
What is
Oh, we know he has said on the last day. We have marked it. How can you say you do not know?
Even appointment, that person, that is not with me. That
then you find out whether you have given appointment or not. Then we will deal with you. Whether you can do this on a pick and choose manner.
Give me my particular
Yes. Take down a specific plea has been
Petition by please, your lordships. My lord, this petitioner was a party to the to a previous judgment dated 16th of March 2020. It was a common order of the CAT. There was a clear direction to comply with the order in accordance with the procedures adopted for the petitioners of WPCD 74. My lord, I have preferred an RTI application where it has been told that no physical efficiency test has been conducted. This is a recent reply, my lord. Your lordship, kindly.
All documents just like that in here, nothing on record.
My lord, this is a recent document, just
So therefore, everything that comes, we should take by hand in a writ proceedings.
no, my lord. That's why I was praying for filing an opposition.
Whatever you want to file, you will file it. We are not stopping you. Let them come with instructions. How they are indulging in this pick and choose, we don't know. Whoever they want, they comply. They give the court that yes, we are complying. And whose face they don't like, they will say we will not do it. Very unique stand they are instructing the councils to take. We don't know. That is why we want them to take instruction.
Grateful, lordships.
Item number 11.
My lord, item number 11 is also same matter, but no one is appearing since Monday. No one is appearing in this matter since Monday.
Next, nobody is appearing next. Not today.
Grateful, your lordships.
Well, Lord, in this matter, learned counsel Sagar Bandyopadhyay is appearing, my lord. He had, my lord, eye operated, my lord. His eye was operated, my lord. Eye surgery, my lord. Only, my lord, 7 days, my lord. Next Friday, my lord.
Now this moves faster. No, this is my opinion of it.
Those people vanish.
Yes, sir. I think.
Filing opposition.
Yes, sir. There is a forgery.
Huh?
On page 3 of my affidavit in opposition. Qaimuddin, son of late Kamiruddin, but another judgment say Qaimuddin is the son of Darbar Ali. He is the resident of Kashibari Post, Haptigar, Chopra, District Uttar Dinajpur. Then
Qaimuddin.
that Qaimuddin is retired in 2014. Roman 6.
Has copy been served?
Yes. It's on 19 February 2024.
None appears for the petitioner.
14.
Reply is filed. Reply filed on behalf of the
The affidavit in the opposition, my lord.
Wait.
কই আমাকে না দিলে কোথা থেকে পেয়ে যাবে? তো তোমার কাছে রাখবেন কি না?
করে অ্যাফার্ম করলো এটা
কেন?
পারে
কেন?
নট অথরাইজ
কেন কি হয়েছে?
কি হয়েছে?
বলছি আমি জানি না
কেন কি হয়েছে?
পারে কিনা জিজ্ঞেস করছি paragraph 6 milord your logically sees for a moment I have to learn something milord your logically sees paragraph 6 my
of your reply.
A person who is not authorized to affirm this application milord the affidavit no designated person জানি না পারে তাহলে আমার আপত্তি নেই
ডেপুটি সুপারিনটেন্ডেন্ট পারবে না?
না পারে না not interested.
Respondent number 3 ke?
Learn something from the court.
Police.
Superintendent of police. Respondent number?
Respondent number 3.
দেখো পড়ে ভালো করে very unfortunately I have to learn it for my lifetime. Is actually in
In the district, in the district there is no superintendent of police, only additional.
no additional. পড়ে দেখো
Because the
Who is
the superintendent he is not authorized.
who is respond number 3? Read
superintendent
the
of police. There is no such post.
Superintendent of police.
No.
Government employee police.
No.
Respondent number 3.
Additional.
No.
Additional deputy superintendent.
respondent number
Additional superintendent of police.
respondent.
Deputy superintendent of police.
Please read who is respond number 3. Please read.
Superintendent of police, government.
Superintendent of police.
GRP.
Yes, GRP.
There is no such post.
Then who has affirmed this affidavit?
DSP.
So has she said that there is no such post, and in such circumstances I have been authorized to swear this affidavit, or everything we are to presume and everything is to be said orally?
No, this should not be disclosed in the affidavit.
This has to be disclosed that there is no post. It has been wrongly described. Affidavit is being sworn under such circumstances.
But it should mention in the. I think my lord friend is correct. It should have been mentioned in the affidavit.
It has to be.
Yes.
How it can be like this? SP or DIG, that doesn't matter. You have to make things clear.
Yes. A person may be authorized by the other person.
It is done every day. In some cases, I don't know whether here it is done. The department authorizes one person to swear all the affidavits. One officer. He has
Your
made
lordship
them.
perfectly correct. But I am grateful to my lord friend pointing out the mistake committed by my lord friend. But this should have been mentioned. But kindly allow me to file reaffirm the petition affidavit.
You can reaffirm, ask him to come and reaffirm soon so that we can proceed with the matter. Then reply is on merits of the affidavit or just on this ground.
Paragraph 14, your lordship.
Let him file first, then we'll see. the affidavit in opposition
Item number 15.
From item number 15 to 19, my lord, are seeking 1 day's accommodation. My lord. I'm good.
Item 16.
19,
16 to 19.
15 to 19.
16 to 19. 15 to 19.
After
Item 20. My lord, 20 to 20, 20 to 25 are all the land loser matters, my lord. My lord, first matter, my lord, this is my reply. I'm filing, my lord. I'm filing my affidavit in opposition. My lord, this pertains to PET, my lord. This first matter pertains to PET, that I have been disqualified, my lord.
কত আমাদের আছে সিরিয়াল নম্বর কত এটা Well, may be permitted to file our affidavit in item number 20.
63.
Reply পেয়ে গেছি না
My lord, this is the yes, man. This pertains to PET, my lord.
My lord, opposition we have filed. My lord, there is, before one report is dirty for filing a supplementary activity. The question is the timeline. 2009-10, my lord. This is very important. Now dealt by Supreme Court also. This entire project was somewhere in year 2009-18. Now, my lord, it's one separate matter. Learned CAD passed an order. The Pandora's box open up. All the 2008, 9, 7 projects, everybody is now coming up. Already 2009-10 project undertaken, compensation granted, it was closed. Now all of a sudden there is a floodgate which is opened, my lord, and these matters are coming up. My lord, one important aspect, my lord, just my lord, inadvertently, my lord, has not been brought into this in opposition, my lord, kindly liberty may be granted in 7 days time, my lord, we will file one supplementary objection. My lord, kindly that is very important, my lord. Kindly a fixed time may be allowed, my lord. My lord. No. Kindly take our opposition. My lord, it starts from page 3, paragraph 5. My lord, the petitioner before my lord. Now, my lord, in 2019, kindly consider paragraph 11. My lord. One more important aspect. Like judgment of the document is something. That my lord is at page 7 of the reply file. My lord is
That is WPCT 88 one that they are relying upon.
After that, my lord, 7 days time. 7 days. No, my lord. My lord, we have never paid for
Kindly.
No, my lord. I have one. Yes.
Grateful Lord. Grateful Lord.
On this list you have appointed. Yes.
Yes.
We can what on this issue, my lord. I am quite unaware of this that one.
Grateful Lord. Yes.
Joseph Kajmi ma'am.
Yes. Joydev Kaj.
The C not qualified at the last. Same result. I was also not aware of this statement. Because to comment from my lord, I came to know my lord that this. No, my lord, certainly not. That has to be my lord. I was not aware of the fact. If my lord may kindly keep it tomorrow, my lord. Tomorrow, my lord. Kindly keep it.
176 fine. That is in my reply, 176 of 2023. I have annexed in my reply. That is the same number 4, my lord.
Yes, 176 of 20. Kindly keep it on Monday, my lord. I will take it such a. Kindly keep it on Monday.
No, not all.
One is different, my lord, where several processes had applied for the same job. One was mandatory, my lord.
No, my lord, that
Only one, yes.
my lord, that does not pertain to these matters, my lord. These matters, my lord, that matter was dealt by your lordships, my lord. My lord, that my lord has told me, the petitioner, to approach the tribunal. We have approached the tribunal. Subsequent to the approaching of the tribunal, they have been again called for document verification. What is going on, my lord? We do not understand. My lord, next matter, my lord, I'm filing my reply. My lord, this is the matter. This is against the file. My lord, this does not pertains to any PET or. My lord, they have not considered till date. No consideration has been done till date. The contempt was dropped. Subsequent to the dropping of the contempt, we approached the. But till date, they have not taken any steps to either they will. Or we approach the tribunal, my High Court, Honorable High Court. This is against the dropping of the contempt. Yes. My lord, the impugned order, my lord, the last page. These are all the identical matters, my lord. Well, OA was disposed of. We filed a contempt. Contempt was dropped on the ground that they are processing. Well, my lord, second last paragraph. Learned counsel for the alleged contender, Miss T. Mukherjee, in CP number such and such, by referring to the compliance report filed in the said CP, submits that sufficient number of documents have been placed on record to justify this tribunal that the whole process of consideration of the land loser for compensation is underway, and the applicant here is also informed that he may submit the original copy of the job application since the same was not found in the department. And we have filed also that. I have annexed in my reply, my lord, that on the page 19 of the reply, my lord, that the same was done. So, my lord, they have stated that the process is underway, my lord. Yes. These are all the same matters upon which the WPCT 88 order was passed, my lord. These are all the. Yes, ma'am. Ma'am. Yes, ma'am. Yes, ma'am. Yes. No, my lord, this was when we come up before the Honorable High Court. Here they have said, also stated that the document was not filed, my lord. Here also, my lord. My lord, their reply, my lord, their opposition, last. My lord, we have submitted, my lord, reply kindly takes up the reply, my lord. I have annexed the document that was filed. They have received the same, my lord. 19/6/2024, my lord. 19/6/2024, my lord. On page 19 of the reply. No, fine. On page 19. 19. One nine. Well, one thing to be one thing to be pointed out, my lord, they are just dragging these man. My lord, kindly, my lord, kindly, my lord. Oh, my lord, he at the time of
Kumar rendered by the apex court. Are we to assume the jurisdiction in all these matters like this? That is the only issue. What they have done is immaterial. You are trying to take us on merits. We are saying, why should we take it up? Before the tribunal has not dropped. It said this document is not there. It has been intimated to you. If nothing is done, you come back. Where is the question of dropping? You see what has said in the last.
At this stage, we drop this.
At this stage, and it is open for the applicant to take appropriate legal recourse if further grievance exists, and you are before the High Court. Because you have just now shown you have submitted in June.
Yes.
This order has been passed in July, just 1 month thereafter.
What is my point of taking this, my lord?
We are not going to go into merits. You are trying to take us in merits. We will not go into the merits. You are saying they are dragging the issue. They are not doing this. So are we to exercise jurisdiction?
Something different, my lord.
Whatever is decided, did you ever challenge the tribunal's order passed in OA? You did not. Then you could have challenged that why they are directing for 90 days. Ask them to issue the order immediately. Nothing can be done.
The original application, we have already submitted the job application. Why I am pressing this, my lord? That they are stating.
Then why did you submit in June 24 again?
Because they have forwarded a letter to me.
Then you have accepted that now we cannot go beyond that. What is this? What kind of submission are you? You say earlier submitted. And then when they say you have not submitted, you submit again. And now you want us to look at the earlier. How it can be? Cannot be. You could have held your ground and said that no, I am not going to give you again. I have already given. It appears that you are yourself not sure.
I am sure, my lord, because
no, your action your conduct does not show that surety.
In order to expedite the thing,
Then let it be expedited. You cannot blow hot and cold everything. You cannot change your stand at a particular date as per convenience and forum and according to forum. This is a specific stand you have taken. We are not going to take up these issues. Pursue the matter there.
Because one more thing, in same issue.
We don't know. Landed Council. Sorry.
I was pressing on the pick and choose. Man, these are the similar circumstances.
Next.
22.
All right. 2 weeks for filing opposition. List after 3 weeks.
Item 23.
23, I'm filing my
23. আপনার appearance list, appearance list. সবাই একই যায় understand. Need appearance.
Yes. Off.
I think that might have similar circumstance matter because the honorable high court.
Same order.
Serial number 4 and 7, my lord.
We are very conscious about jurisdiction issue. We are very conscious, sir.
Important by second hand over the judgment, my lord, that was dealt by the coordinate
Not in such circumstance.
circumstance, my lord. Lord, I can produce the orders. My lord.
The issue is not concluded yet. The issue, unless once it concludes, the issue may be different. You are trying to jump to the High Court immediately after touching the tribunal. That we are not. I am very conscious about this jurisdiction issue. Once it is done, then you come. Nothing complicated. The same order is there, which we have just.
I am because these two persons have already got appointment by virtue of the honorable court.
Who has got appointment?
Serial number 4 and 7.
Good for them.
They are candidates.
Good for them. So you go and tell the tribunal that, look, this is how they are proceeding, pick and choose. In every case, we are finding pick and choose. There is something there. No, no, same as the one job dictation here. 21. No, 28. Just now you gave the date. 28/6.
Yes, talking about something else.
We don't know whether they will get or not get, but we are on the jurisdiction issue only. Yes.
24.
Twenty-one. 22. 23 order. Central. 23. So Monday. Same. Here also 19 June. So same as 21. 6/6/24 you have filed. Anyway, 6/6/10/6 does 6/6/6/6/24 submission of application. 6/6/24.
Same as 20.
Writ petition August. Writ petition filed in August. In 24, none of them have been offered appointment yet. No. In the earlier one, 2 had been appointed there.
Similar for
No. In 24, none of the petitioners have been appointed. 23, you said 2 persons have already. How can they all be petitioner in all the cases? You said petition number 4 and 7 or somebody has been appointed. In 23, you said 2 of the petitioners have been appointed. What is this?
The list, madam, the list.
Why list? You said petitioners have been appointed, two of the petitioners. No, you did not. You said two of the petitioners have been appointed. We have recorded two of the petitioners have been appointed. Everybody. Oh, delete that. No, we'll go by his date. You have received it one day. That is not 18/6.
18/6, they have received.
18/6/24. Same order.
Hey.